Mention.
Yes.
I beg to mention item 40.
Item
Number 40, my lord. 40.
40. Yes,
I am praying for listing the matter in December, my lord.
December. What is there?
My lord, I am yet to file affidavit in this case, my lord.
What affidavit? It's a regular first appeal.
But I feel, my lord, sir, some I need to file affidavit as my lord.
It's a question of law only.
Yes, my lord. But that question of law in this particular case need fake, my lord. Depend on fake, my lord.
On the prayer of Mr. L. Permanent Counsel for the respondent in the prayer not being objected to by Mr.
A. Sir, my lord.
A. Sharma, learned counsel for the appellant, list this matter in the
First
month
week
of December.
Any date, lordship, kindly, lordship. Just any date,
December was too long, we don't know.
lordship.
Tell us the date.
4th of December.
4th of December, huh?
High level.
Oblige.
Please, Your Lordship, I may be allowed to move one unlisted motion.
What?
This is a criminal writ, Your Lordship.
Hmm.
We have sought for direction of investigation and registration of FIR.
Tomorrow.
So
There's no urgency tomorrow.
the item is bit related with today's item number,
We'll see tomorrow.
if time permits, Your Lordship.
We'll see tomorrow. There's no urgency.
Why I'm saying, Your Lordship, because today, in the today's list, item number for this case is bit related with item number 4.
You have not filed. You have UAS.
That is already in process.
Huh? It's
that is-
only process. We'll take it up tomorrow. What's there?
Lordship, I would like to mention item number 25, Your Lordship.
25.
Yes, Lordship.
Yes.
My Lordship may kindly take up this matter on 20th of November, Your Lordship.
Why?
I've taken the consent from the petitioner, Your Lordship.
You have not filed
No, we have to file affidavit.
on the prayer of MS Arbasar London State Council. Further 3 weeks' time is granted to file affidavit in
My lord,
opposition.
a fixed date may be given.
Hmm?
A fixed date may be given. Kindly.
Mr. So-and-so Learned Council appears for the petitioner. List on
20th, Your Lordship.
11.
May I please, Your Lordship?
Okay.
May I please, Your Lordship? I'd like to mention item number 26, Your Lordship.
20,
26, Your Lordship.
26,
Updated
yes.
city was called for, Your Lordship.
Yes.
But Your Lordship, I will appear physically, Your Lordship, because I have some network problem here. Your Lordship, kindly matter be fixed on 31st of this month, Your Lordship.
31st is something. What is 31st?
Friday, Your Lordship.
Okay. On the
And Your
prayer of
Lordship, the interim may continue, Your Lordship.
S. Nasilin Learned Council for the applicant. List this matter on 31st 11/2020.
31st of this month, Your Lordship. 31st October, Your Lordship.
10, yes.
Your Lordship, and the interim may continue, Your Lordship.
Obviously, have you appeared?
Yes, Your Lordship, I have appeared, Your Lordship, before the IO, Your Lordship, on the
Bail has
5th,
been
Your Lordship.
granted. You have
Yes,
been
Your
released on
Lordship.
bail.
Yes, Your Lordship,
Have
he's
you
on
been
interim, Your
released on bail?
Lordship. Sorry, Your Lordship.
Have you been released on bail?
Yes, Your Lordship, he's on interim bail, Your Lordship. He's appeared before the IO.
31st 10, yes.
May I please? My lord, item 12 and 13. In fact, record was called, so I have not yet received the records.
On 16/6 of this year, that order was passed to produce the records. The tender matter, they have not got the records till now.
So records will be required.
It will be required, lordship, because
Sure.
that is the issue.
Yes.
And we are also
on
filing
the-
additional
Takes
affidavit
up.
today, lordship.
Mr. G. Tarak, London Standing Council RWD submits this. Although records would be required in this matter, he has not received the same. Therefore, prays for listing the matter after
2 weeks.
2 weeks.
On 4th of December, lordship, there's
Mr.
another matter fixed. It will be on 4th of December only.
4th of December.
Yes, sir.
All these matters can be taken up in a day.
Then lordship will fix any date. I'm just for convenience, I was saying
Anyway,
that one matter was fixed on 4th of
as agreed
December.
to by London Council for the parties No, I mean, Mr. A. Sharma, learned counsel submits that matter may be fixed on 4th of December. Right? Mr. has agreed to by learned counsel for the party. Let this matter be listed on 4th December.
To produce the record first.
Needless to say that on the next date, the learned standing counsel shall ensure that the records are produced.
Yes. Obliged.
May it please your lordship. Lordship,
Yes.
I beg to mention item number 11, my lord. In fact, it is only yesterday that I have come to know that it has been listed today as item 11 since no fixed
Only
date was
prayer of
given.
Mr. When do you want?
My lord, 7th of
This was
November,
learned
any
counsel for the petitioner. Is this matter on when?
7th of November, my lord.
7.
7th
Yes, yes.
7th of November.
Yes, 7th.
My lord, there is an interim order
Interim
that may
order
continue.
passed earlier shall continue. Okay.
I am deeply
Next.
obliged, my lord. I am deeply.
My lord, I beg to mention item number 39, your lord.
13.
39.
Why?
My lord, Mr. Panging, within council, he has some personal difficulty.
Any affidavit has been filed?
Yes, sir.
Yes, government. If the affidavit is filed, we'll take it up to today. What's there?
My lord, can it be then taken up tomorrow, your lordship?
Not tomorrow. Tomorrow will be other cases. Yes, affidavit has been filed.
Yes, your lordship.
What is your stand? Are they entitled or not?
Yeah, my lord.
Go through it. They will dispose of the matter. What's there?
Today, my lord.
All right, your lordship.
Where is Mr. Pangi?
My lord, he has some personal difficulty, your lordship. He could not be here today.
We'll see. Go through the briefs, both of you.
Much obliged.
May I please, your lordship? Lordship, I beg to mention one unlisted item which is pending before this court. That is one service matter, lordship. Kindly this matter may be listed tomorrow for withdrawal,
Withdrawal.
lordship.
Withdrawal, we'll list it today. What's there?
Lordship, tomorrow.
Today. If it is for withdrawal, it will take hardly a second.
Lordship.
Today. Get it.
Yeah, Lordship. Lordship, I would like to mention one unlisted matter.
What is the urgency?
Lordship, the appellant is convicted and he is in a jail. So,
Appeal. Criminal
so
appeal.
yes, this is an
It will be listed. You file it. It will be listed.
Your Lordship, the matter has been last listed on this 26th
Next week. Next week.
next week. Much obliged.
Next week.
May I please, your lordship?
Yes.
I beg to mention item number 4. Say, it's a criminal petition. Charge sheet has been filed. So, I may be given 1 week time for filing affidavit along with this.
Huh?
My lord.
Affidavit, what affidavit?
For bringing record, copy of charge sheet has been already filed by the police.
So you want to bring on record with
Yes, my lord. Yes, my lord.
So you file fresh. Withdraw and file fresh along with all those. You'll have to say something on the charge sheet also, no? Right?
Charge sheet, my name is not mentioned. I am not charge sheet.
That's a crucial thing. We'll see. If your name is not mentioned, what's there? That's why
Yes.
on the prayer of Mr. Udeka, learned counsel for the petitioner, this writ petition is allowed, this criminal petition is allowed to be withdrawn. Accordingly, criminal petition is withdrawn with the liberty to file afresh. You file afresh,
Okay.
along with that. Let us not make it clumsy.
Yes. Item number 1.
For full evidence.
It's not willful. The direction is for consideration. Some of them have been considered in accordance with law.
Out of what petitioner?
Yes.
who has considered?
What's the way? This was no positive direction for regularization. It was for consideration as per the law. Whether there's been whether the regulation They have complied with the matter. Complied with the order. What is the only recovery from the following conditions? 25.
Yes.
26 is type copy. Yes. Why you are not, why these other two candidates have not been regularized?
There is no any justification. Even we have filed petition.
You have to challenge that. There's no willful disobedience. Is it pursuant to the order of this court?
Yes.
Then,
Madam,
see, what we have directed is you are entitled, but then it has to be considered.
page number 21.
I will be considered to have considered this and so. It is directed that the respondent shall consider the case along with other similar persons for regulation of service in accordance with. Consider. You have been considered and not been regularized.
Out of 4 petitioners, 2 was considered.
It's all right. That's why your case has been considered. You might have not been found to be eligible for regularization in
Madam, there is no
as per the rule. Huh?
there is no justification. As per this order,
See, what I'm saying is there's no willful disobedience. Anyway, heard Mr. O. Modi. You think about it. You'll have to challenge that. Find out the DPC minutes, why you are, whether you have been considered or not, your cases. O. Modi, Learned Counsel for the petitioner. This is an application under what is this? Section 12 of Contempt of Court Act 1971, read with Article 215 of the Constitution of India and Contempt of Courts Act, Guwahati High Court Rules 1976, alleging willful and deliberate disobedience of order dated 16/6/2025, passed in WPC 432, issue notice returnable by 4 weeks, and counsel for the 6 days resolution notice.
Item number 2.
Go to civil court, what's there? It's better.
No, my lord. Because, my lord, the customary court is the recognized institution, my lord, which has been vested with the power to adjudicate, my lord.
What is
When the party is indigenous and from the same locality.
what is the pecuniary jurisdiction?
They don't have the
Unlimited.
Yes, unlimited.
It's maybe, but then it's not proper.
It's not proper that, my lord.
Higher court, I mean, the civil courts has a certain limitation. And the customary courts having the lower than the civil court
That is for
is
the
unlimited.
legislature, my lord. That, of course, my lord, does not seem good, my lord.
So what's wrong here?
The wrong is that, my lord, since they have been vested with the power to adjudicate, my lord, but they are denying to apply their power, my lord.
We'll issue notice only.
My lord, may kindly dispose of the matter because, my lord, the law is very
No,
clear here.
without-
The issue is very simple. My lord has seen, my lord.
No,
But
we cannot.
Though they are vested with the power to settle the case, my lord,
See,
but they are not exercising there is a power, my lord.
I
So
think
other,
it appears that they have taken a right decision.
No,
to
my lord.
direct you to approach the civil court.
no, my lord, they have to adjudicate the matter, my lord. They have to decide the issue, my lord. They have not decided the issue.
Yes, we'll issue notice. No interim order can be passed and it cannot be disposed of without hearing the other side. Right?
My lord, my humble understanding
Yes.
says that, my lord, since, my lord,
This will be affected. He may not like to be, suppose if the respondent doesn't want to be, because he was also not present.
he was
He may-
not present, but then, my lord,
He
the
may not like,
day
the-
before,
he may not like the the customary court.
My
You
lord, they-
cannot bar,
my lord,
bar them from.
see the
approaching
conduct of the
civil
respondent, my lord.
court.
My lord, see the conduct of the respondent, my lord.
It's
Day
not a
before,
conduct, sir.
2 days before this mail, my lord, the respondent, they have filed their written statement. Despite that, my lord, order they fixed
It's a
for the,
matter of principle of natural justice. We'll have to hear them. Definitely we'll dispose of the matter on their appearance.
then my lord may kindly pass interim order, my lord,
What interim order?
to keep in evidence the order passed by the my lord customer
Doesn't make
court.
any difference. If you have been directed to approach, if you don't approach, matter will remains like that only. Who has filed a complaint before the
Me.
customer? Them? You have been directed. I mean, they have decided you to approach the civil court.
That is the wrong, my lord.
So
The,
if you are not
wrong,
see, if you are not approaching, what's there?
that is why,
You
my
don't
lord,
approach.
the petitioner is agreed by the order passed by the mail, my lord.
You don't approach the court till the time this petition is disposed of. Anyway, had Mr. D come to learned counsel for the petitioner. Agreed by the decision of what village, where it is? Order dated 30th,
30,
3008/2025.
38.
Passed by the customary court of village, customary court of model village, Naharlagun. These are the things now happening. Is it permissible all this kind of using this?
Yes,
Where? Under which notification or law? Customary court is customary court. You cannot act like a regular court. Anyway, customary court of model village, Naharlagun, whereby the case instituted by the petitioner has been no, whereby the petitioner has been directed, whereby it is recommended that the matter be tried before the regular court, public civil court of competent jurisdiction on the ground that, whereby the customary court has advised and recommended the case of the petitioner be tried before the regular court, public civil court of competent jurisdiction on the ground that the respondent is not cooperating with the customary court by denying all the documents, public evidence by way of written statement. Huh?
yes,
They also say, they call also it's a written statement.
yes.
This stuff. It is the contention of Mr. D. Kamdu, learned counsel for the petitioner, that the customary court has refused to exercise jurisdiction as conferred under the law.
Yes, ma'am.
Therefore, the decision, the impute decision recommending to be tried by the trial court, public civil court of competent jurisdiction is not sustainable. This issue notice to the respondent. One. Only-
Yes, my lord.
Only one respondent.
Only one.
Sole respondent returnable by 4 weeks. The learned counsel for the petitioners to take steps for service of notice upon respondent, sole respondent by restore so and so. Considering the next submission of learned counsel for the petitioner, and also considering that the customary court of model village appears to have not exercised jurisdiction conferred upon them under the law, till the returnable date. The impugn order dated 30/08 so and so so and so shall remain. It's meaningless. Shall remain suspended. Shall remain suspended.
Yes, my lord. Yes.
What is there? You have been directed. Our respondent will not go to they will not approach. Obviously, it is you to approach.
Whatever, my lord, this may
If
be.
you don't approach, okay.
Much obliged.
Matter number 3.
Heard Mr. So and so learn counsel for the petitioner. What is the order? Page number?
What's the page number? 68, Lord.
68.
Yes, Lord.
This is by whom?
LGB
Village
custom-
authority.
Yes, village authority of Lipu village, my lord.
Saying what?
Saying what that they have decided the title in favor of the respondent, my lord.
Where it is? Operative person?
Page number 86, my lord. Second paragraph.
Which is pending before the civil court.
My lord, here what happened, this village authority has issued a parwana to me, whereas the disputed land is located at Gogar village. I am from Gogar village and the other
Now
party
you
is from.
said that same issue is pending before the
Yes,
civil
Lord, sir.
court.
After issue of this parwana, I had met the AGB of Lipu village. I told him that I am also willing to settle the matter, but through a proper forum. Since the Lipu
No,
village.
no,
has
I'm asking, you have said somewhere that
Yes,
the
Lord. My lord.
matter is also
Yes.
pending before the civil court.
Yes, my lord.
Is it
At before the civil
same
senior division.
dispute?
Same dispute between the same parties, my lord.
What is the name of the land?
Gogar lane, my lord. Gogar lane located at Gogar village. I am from Gogar village. The other party is from Malini village, but the customary court of Lipu village has decided the matter, my lord. And by making all the entire HGB and GBs of Likavali
what
circle
I
as a
said?
member.
Yes. Heard so and so, learn counsel for the petition. Challenge made in this petition is to the order dated 26.
22/8,
Huh? 22/8.
22/8/2025.
22/8/2025. By the what? By the
Customary court of Lipu village.
Customary village court of Dipu village, whereby a disputed land, a disputed plot of land located at Malini village near Gogar River has been decided in favor of the respondent by way of an expert decision. It is the contention of the learned counsel for the petitioner that the land, the disputed land is situated at Gogar village,
Yes, Lord.
whereby the village authority, for which the village authority of Gogar village
Yes, my lord.
is the only village authority to decide the matter.
Yes.
In the, by the said decision, by the impugned decision, the authorities, village authorities are consist of other adjoining villages
Yes, Lord.
who would not, villages having no jurisdiction to settle, to decide the said disputed land. Mr. Issue notice returnable by 4 weeks. Petitioners to take steps for service of notice upon respondent, so it's, sole respondent.
Sole
Only one
respondent,
respondent.
sole respondent, my lord.
Next para. Having considered that the privacy, the land situated at Malni village near Gogar River, which falls under the jurisdiction of Gogar village, and also considering for which the village authority of Gogar village is the competent authority to decide the matter. And also considering that the village authorities of other villages have participated and taken the decision that to ex parte, I deem it appropriate to pass an interim order. I deem it appropriate to pass interim order, Mr. Accordingly, till the returnable that the impugn order dated so and so, so and so. 22/8.
22/8.
But this is signed on 26/9/2025.
This is certified copy, my lord.
Okay. 22 shall remain suspended.
Yep, yep.
Item number 5.
Yes, sir.
I am filed this ancestry bail application.
What is the offense?
Criminal breach of trust, cheating and mischief. This is actually a family discord which has resulted in this.
Okay, we'll call for the
Yes, ma'am.
case diary. Let him go on bail, but you appear.
Yes.
When you would like to appear.
Earlier, he was granted bail, madam, by the session court. Interim protection was granted, but later on it was cancelled because,
That's why we
yes.
heard Mr.
N. Saha.
Learned counsel for the petition, N. Saha. Learned counsel for the applicant. This is an application under section 482 of BNSS 2023. Seeking privilege of free arrest bail to the accused applicant in connection with Nezuli PS case number 71 of 2024 under section 317. So, na? Page 1. BNS 2022. Call for a skill copy of the case diary. Mr. P.F. London Edison PP appears for the state. Next para. Why you should be granted interim bail?
Lordship, actually, the earlier anticipatory bail was granted by this learned session.
It's all right, it's gone.
But
That has
here,
been cancelled.
here the point is that he is ready, the applicant is ready to deliver
It's a
the
dispute
ornament.
between the family members.
Yes, yes. Family members, actually, applicant is the paternal uncle of the informant. And he has taken care economically, educationally, upbringing of this informant.
Who?
Applicant,
Applicant.
yes.
Informant is nephew,
Yes, yes. Niece.
niece, lady.
Yes, yes. Girl.
What is the dispute?
Disputes, actually, there is several land dispute. Writ petition is also going on regarding the land dispute before this honorable court.
So
And
what is the allegation
And
here?
this land, due to this land,
What is the allegation here?
allegation is criminal breach of trust of possessing of ornaments illegally, which has been delivered 17 years ago by the mother of the informant. 17 years ago, ornaments.
Criminal breach of trust.
Yes, my lord.
Yes.
The
And there is
ornament-
no actually dishonest intention and misappropriation as required under this section.
Next para, considering the submission of learned counsel for the applicant, also considering that the disputes is in between the family members who being the applicant being the uncle and the informant being niece relates to the property, family property. I deem it appropriate to grant pass the interim bail list accordingly. In the event of arrest, Ms. So-and-so, the so-and-so shall release on bail and furnishing a bail bond of rupees 25,000. And one insurative like amount to the satisfaction of the arresting authority on the following conditions. Petitioner shall appear before the IO, investigating officer, within 10 days from today. Any day you appear, right? And then same two conditions, right?
next date, my lord, let it be on
Based on
12th, my lord.
12th of November,
Yes, my lord.
12/11. It's too long.
Yes, my lord.
After 10 days, you just suggest it.
Let it be on, my lord.
6 or 7,
Okay, 7th, my lord.
7.
Oblige.
Item number 6.
Why you are fighting for this transparent posting place? It appears to be because of that only.
Yes, my
Unnecessary.
My lord, this honorable court has already passed order in my favor.
It's all right.
So
Why to fight?
I had not
Using
taken up.
revolver and all.
I had not taken up the fight, my lord.
Yes, Mr. Tado.
Yes, this is a case of complaint and counter complaint.
Yes.
And there was a scuffle
That's what I'm
between
saying.
them.
Couple, it's the
Yes,
NS
yes,
the cause is the place of transparent posting.
yes, exactly.
Posting place. Unnecessary. Anyway, heard Mr. So-and-so learn consent for the petition applicant. And this is an application 482 BNHS. Praying for privilege of pre-arrest bail. Pre-arrest.
Yes, my lord.
In connection with Mahadevpur Police Station case number 27 of 2025 under section 115 within bracket 2 of BNS read with section 25 of Arms Act 1959.
Yes,
We
my
have used the revolver.
No, my lord. When this complainant attacked me, the revolver that was under my waist, he tried to grab it. And
Grab
then
that,
we had fight.
hit himself by
Then thereafter that
nozzle.
he hit himself with the nozzle and went out of the.
He's a complainant is eccentric.
Yes, my lord.
He is eccentric or what?
I-
Otherwise, how will do that?
Allegation is there that
Allegation is that my lord.
one,
Because in
one
that case, they are
each
getting
All
the
the
police.
case
against each other.
copy of the case diary. Yeah. Mr. G. Tado, learned additional PP, case to the state. Having considered the considering the submission of learning principle. No, I have considered the submission of learning principle for the applicant, and also where is the grounds and the materials annexed to the petition. Considering above, I'm inclined to grant an interim order, just according in the event of considering the nature of allegation, although and the submissions, although an offense, offense under section, under Sales Act 1957 has been registered, in the facts of the case, I deem it appropriate to pass interim order, interim bail order, according in the event of arrest, so and so, 25,000.
Deeply
Apologize.
So you will have to appear.
Yes, sir.
When? Within 10 days.
Within 10.
10 days, List on 7.
Apologize. Matter number 7.
May I press your lordship?
Yes, they have settled everything.
No, not your lordship.
What?
Your lordship will see the settlement has been done with another person, your lordship. And the settlement was done, in fact, the complaint was filed after the settlement
It
was.
was a mistake of fact.
No, your
Yes,
lordship.
mistake of
I'll-
fact,
I'll
not the
just-
victim.
I'll just apprise your lordship. If your
It's
lordship,
okay, we'll issue a list. Nothing. These are all,
My lord, keep the stay order so that the stay order regarding the death proceeding.
what is the amount involved?
no, your lordship,
To like
your lordship, I'll
already
just-
paid.
That has been, amount has been paid back.
Paid.
Not to me, your lordship. I'll just
It's
apprise.
okay,
your
you have not paid, you file and shoot.
No, your
Yes.
lordship,
Civil suit.
Recovery of your
I'll
money.
just apprise your lordship.
Yeah.
Lordship, the amount has been paid to the travel agent, your lordship.
Hmm.
Against my GST that has been used after the settlement was done by the, with the
Settlement
travel,
is on the basis of what? Saying that was a mistake of fact.
not
The
misusing my
fact.
GST number.
employees of the petitioner has some misunderstanding or
No,
mistake
your
of
lordship.
fact.
Therefore, I'll just apprise your lordship. I'll just bring your lordship to page
And
number
these
30.
are all unnecessary.
No, only
Please.
page number 38, your lordship.
Yes.
If I may just, because the complaint was even filed after the agreement was done with the other party, your lordship.
Yes.
If I may refer to paragraph 10, your lordship.
Hmm.
That in the month of December 2024, the complainant received a copy of money receipt, apology letter, and deed of agreement executed between Srimati Likhayapi and Nikhil Jain, proprietor of so-and-so, indicating part payment made towards the dispute amount from the advocate so-and-so through WhatsApp message. This clearly established that the accused person were the actual beneficiaries of the ticket book and misuse the complainant's GST number to obtain tax benefit or avoid personal liability. This is the case, your lordship. It's not a case of mismanagement or of the amount, your lordship. And in fact,
So according to you, they have misused the GST number
in
to obtain tax benefit,
yes, your lordship.
fraudulent.
Yes, your lordship. They had on my taking benefit of my GST number. They have booked all the tickets, not paying any amount. It's when
Now
he-
it has been paid.
no, it's when not to me, your lordship, to the travel agency from which the ticket of the flights were booked, your lordship.
Hmm.
Those monies
So
were
what do you
paid
want?
to the your lordship,
What harm has been caused to you?
the GST, your lordship.
So what is it? What harm?
Because I was not informed that my GST number was,
No, that's
Being
what I'm
used
asking.
against-
What harm has been caused to you?
because I have been given a notice of for the tax evasion, your lordship.
That's all.
That's all, your lordship.
That's why I will stay. Nothing.
My lord, regarding this matter, my
No
lord,
serious harm. Has your reputation been is in stake
Yes, your lordship,
because of this?
it was behind the
Well, direct
complainants.
them to make good of it.
Yes, your lordship.
That because it was a case of mistake of fact something.
mistake of fact only. There is no any masaria, no fraudulent, no any illegal act, your honor.
All your
Mistakes of
businessmen,
fact.
It's
It's employee.
it may happen to you tomorrow also. Right, not you, the
I understand,
complainant,
Lord.
not the PP, obviously. Heard Mr.
Embagra.
M. Bagra, learned counsel for the petitioner. This is an application, so and so, 528. Praying for quashment of the proceedings, we'll say proceedings.
Proceeding
eh?
and summoning orders,
Summoning, summons
summon orders.
dated 0409/2025 and 30/06/2025. and the criminal and the consequential criminal and the criminal proceedings in criminal miscellaneous application number 174 of 2025. Pending before the Chief Judicial Magistrate.
Judicial Magistrate First Class,
Judicial
UPA.
Magistrate First Class,
Yes,
UPA.
UPA.
List of issue notice returnable by 4 weeks. MS so learned counsel for the learned additional PP. TG, additional PP. Appears for the state. Where is the state?
On the next day, 29 of this month, they appear before the Honorable Court.
Learned counsel for the petitioner to take steps for service of notice upon response number 2. Barrister posture, call for the scanned copy of the trial court record. List of next para. Considering the nature of the allegations and the averments, and also considering the submissions and averments made in the petition, it is provide this court. No, I am of the considered view that the interim order is called for list of accordingly in the pending production of the trial court copy, trial court records, the further proceedings, including this summon dated so and so, 2 summons shall remain suspended.
So may stay the proceeding, Your Honor. Much of
2 weeks elapsed.
4 weeks.
Deeply.
I mean 3 weeks. Say 3 weeks.
deep obliged.
Item number 8.
May I please, madam?
No affidavit.
No, but my lord, this can be, my lord, considered, my lord. My lord, the petitioner,
Let us list for hearing. Let us list for hearing.
my lord, in
This
the
is for-
pendency of the writ petition, my lord, they have, my lord, accessed our property, my lord, and my lord, and the amount has been released by the BRTF to the deputy commissioner also, my lord. Which is paying, my lord, is before the deputy commissioner. And we have also sought, my lord, in this writ petition, my lord, the solution and the interest, my lord. Now, my lord remembers, my lord, Mihin Amin case, my lord. This was disposed of by the Supreme Court, my lord, saying that, my lord, the lane owners, my lord, will be, my lord, eligible for, my lord, solution and interest, my lord, in terms of the new act, my lord. Subject to that, my lord, it should be pending, my lord. The closed, my lord, acquisition, it will be not
Pending, including the pending before the High Court, tribunals and courts.
So now, my lord, only, my lord.
But if it is determined and settled,
Settlement.
it will not be reopened.
Yes,
So your case falls under pending
pending.
cases.
Yes, sir.
It required, I think, considerable length
Yes.
of time to
In
hear.
in that event, my lord, may I pray that, my lord, I may be, my lord, allowed to, my lord, take those, my lord, compensation, my lord. With a process, my lord.
Accept.
Yes, yes.
Obviously. You go and ask them, they'll definitely, under the act, you are, under the law, you are entitled
Yes, sir.
to accept the on
Just
one
make an
process.
observation, my lord.
We'll just say pendency shall not be, as
Fine.
it is recognized. Huh?
Right.
Heard Mr. Arsaki, learned counsel for the petitioner. Petitioners, only one.
Two petitioner, my lord.
Petitioner. Next para. Despite several opportunities granted to the state respondents, no affidavit in opposition has been filed. As on the list of Mr.
Your Lordship,
Why did
Your Lordship, we would like to rely the affidavit in opposition filed in WPC 3 of 23, Your Lordship.
Where it is?
That has been disposed of, Your Lordship.
So how can we dispose of matter? How can
Yes.
Mr. will not record that? That will be very, it will be not appropriate to record your submission.
Yes, sir.
Mr. Hoyer, Learned Counsel for Learned State Council submits that he may be granted a last chance to file affidavit in opposition. Prayer not being objected. No, considering the nature of the grievance raised in this petition, the prayer of the London State Council is accepted. So accordingly, further 3 weeks time is granted. 3 weeks.
Yes, sir.
Otherwise, they will not file. 3 weeks time is granted to file affidavit in opposition as a last chance. This is the next paragraph. On the the Mr. Arsik, London Council for the petitioner submits that since the amount of compensation has been determined during the pendency and has been released by the requiring authority before the deputy commissioner, district collector, we may be allowed to receive the amount assessed under protest or on protest.
On protest.
On protest. Considering that the law permits the landowners, public, the affected interested person to receive the amount awarded, it is directed, it is provided that the petitioner the responding authorities may release the amount assessed to the petitioner on protest in accordance with the law. Just after 3 weeks.
Public.
Item number 9 and 10.
You are not pressing the IA and the contempt. IA is for what?
IA is for my lord, for stopping the work, my lord.
So you are not pressing it.
Not pressing right now, my lord. If it is.
And
the
contempt is
requisition
also
disposed
not
of.
pressing.
Right.
Both disposed of. Not Mr. So-and-so, then counsel for the applicant who submits that is not pressing the IA, intellectual application for the application stands.
Then
And the IA stands closed, and disposed of. Then contempt, So-and-so. Same order. Stands closed and disposed of. Contempt, Both. Then writ petition is to be done. What?
it has to be disposed of, my lord.
How?
My lord, because my lord.
Pleadings are
Deputy
completed.
Commissioner has completed, my lord. Deputy Commissioner has, additional Deputy Commissioner has passed the order conferring the title over the my lord, private respondent without jurisdiction, my lord. Well, initially, my lord, this is second round of the writ petition, my lord. Initially, my lord, Lords will find at page 57, my lord.
Is there any urgency?
My lord, this can be disposed of, my lord, because, my lord, there
What
is
is- what-
urgency, there is
what-
the urgency, my lord.
What is their claim? What is their response?
Response is that, my lord, they have, my lord, the deputy commissioner, my lord, additional deputy commissioner, has, my lord, referred the matter under section 38 of the AFR, my lord, which is a manner obsolete provision, my lord. As, my lord, by section 27(6), the section 38 of the AFR has been, my lord, deleted, my lord. Kindly see, my lord, the affidavit of the respondent number 1, my lord. case 12, my lord.
There,
Whereas
in that case, otherwise there's a other provision for reference.
My lord,
There's a provision for reference.
yes.
Wrong ma-
No reference, my lord.
Huh?
My lord, if my lord, a complaint is being filed before additional deputy commissioner or deputy commissioner, my lord,
Yes.
the matter has to be referred back to the my lord under section 10 of the 10, subclause 4 of the section 10 of Arunachal Pradesh Civil Court Act, Amendment 2022, to refer back to the my lord, the appropriate customary court or the village authority, my lord,
By whom?
by the additional deputy commissioner.
Huh?
By the DC or the deputy commissioner or the additional deputy commissioner. If the complaint is being made to the my lord, deputy commissioner.
So in that case, the principle for that law with regard to wrong mentioning of the section,
My lord.
unless it goes to the root of the matter,
Yes.
will not have.
Well,
any-
here what happened, my lord?
Huh.
Initially, my lord, my lord, narrate the fact in a brief, my lord.
No, what I'm asking is, it is to be disposed of today.
Yes, my
because
lord.
we have so many matters, bail matters are also there.
My lord, just my lord, my lord, deputy commissioner could
We'll
not have,
see.
my lord.
After the completion, will if it's to be heard, let us complete the list first. Liberty, personal liberty is not at stake.
No, however, my lord, the land is under the occupation of the private respondent, that's why.
Okay, so we'll dispose of, after we'll complete the list first. All right.
My lord,
Take it
I
up.
am not agree to that. Since my lord,
You want to go early or what?
my lord, since my lord, learned council is not pressing, IA number 71, even contempt also.
That we say close.
My lord, in that case, my lord, since pleadings are over, you'll also fix a particular date for final disposal, my lord.
I have,
My lord.
my lord, praised because, my lord, if my lord, this petition may be on.
No, today is for IA, my lord, especially for IA. So we are not actually ready for repetition, my lord.
In that case, next week,
Next week, any date.
because
Then, my lord, let my lord, IA and contempt remain, my.
no, we have already disposed of, Huh? No, he may be correct. This IA is listed.
Yes.
These are complete, my lord, that's why, my lord, in the
right.
admission column, my lord.
No, that's why I'm saying, I'm ready, this court is ready, but he said that this is for IA. He's not ready.
Yeah,
Because
but
you have raised the legal issues.
only questions of law, my lord.
That's why he needs to be prepared. Or he doesn't want to be stay back in the afternoon, second half.
Then let it be tomorrow, my lord.
Tomorrow there will be other cases.
Tomorrow is not a good day. Next week, my lord, any date, my lord.
Then we'll fix it on 30.
My lord. My lord.
No. Today is what? Today is, my lord. Today is 27 November.
30, Thursday. As agreed. When? Then?
My lord, may, if my lord see the record, my lord.
5 or 6 like it. No, 5 is already there, then 3 or 4 anywhere.
3, make it 3 hit that.
My lord, 6.
6. As agreed to heard Mr. So-and-so, petitioner. And Mr. So-and-so. All of them, you record there, huh? R.S. Nabar, learned additional advocate general for state respondent, and Mr. D. Bayer for respondent number. Pleadings are complete. As agreed to by learned counsel for the parties, let this matter be listed on 06/0/11/2025.
Item number 14 and 15.
Please, Lodge. Please, Lodge. We have to Lodge. There is an order passed by the Honorable Supreme Court which we want to place before Lodge.
What order?
Lord, I appear in Terence on behalf of respondent number 4, Lord. And I'm so sorry, my lord, due to paucity of time, I could file my reply this morning itself. I've sent copy to the other side. I don't know whether copy is there. I can hand over a separate copy for the honorable court, my lord.
And the scope for hearing on 27th October. However, we are not got to make an endeavor to decide the same on or before 30th October. The petitioner is at liberty to raise all the objections as available to him.
But the Honorable Supreme Court refused to interfere. I don't know for what grievance they have gone to the Supreme Court, my lord. Because
Lord,
your
this is my
lordship last,
petition, I'm sure, my lord, my learned friend will permit me to, my lord, I was there.
I
my learned
just
friend
wanted to point out, my lord,
I
that
will apply to
last
lodge-
order, there was no relief granted or no relief was declined by my lord. I just wanted to place that. I'm not disputing the fact that my friend has placed this order before this honorable court, my lord. Your lordship's last order issuing notice was challenged before the honorable Supreme Court, my lord. But no relief was granted or declined in that order, my lord.
The Honorable Supreme Court only
This
said,
is just a tactic to create pressure here that this matter be disposed of as soon as possible, my lord. I don't mind, we can continue hearing the matter and get it disposed today, my lord. I just wanted to place this on record for my lords, my lord.
Which one? The affidavit.
No, my lord,
Affidavit.
your lordship's last order of 22nd September, my lord. That has been challenged by the appellant here before the Honorable Supreme Court. Though the Honorable Supreme Court refused to interfere, but there is a observation requesting this Honorable Court to decide the matter.
the Honorable Supreme Court only said that we are not entertaining the special leave petition because the matter is already coming up.
It is
before
almost
lordships
as
on
good as
20
declining the relief that was paid for.
Because I'm sorry, I am in the midst of my argument. I'm sure my learned friend will give me
I'm
that
so
opportunity.
sorry, you are placing a document which is not on record. So I have to point it out to the Honorable Court.
Please have the order passed by Lordships Milord on 22nd September for a minute, please. The Lordships have the order of 22nd September?
We'll take after the, this is for disposal.
Yes.
Take after the, all other matters, sir.
As a
No problem at all. Obliged, my lord.
Item number 16.
Your Lordship, I may request the matter may be fixed for the next date now.
Why?
Your Lordship, leading counsel is not present.
Yes,
But,
on the
anything-
ground that the, Mr.
next week, my lord.
Who is the leading counsel?
Tea keeper.
The and counsel for the petitioner. Is indisposed, Mr. Swenso, learned counsel appearing on this, on his behalf. First for listing of the matter. This, after a week, prayer not being objected to the understand.
May I pray, my lord,
List of the learned counsel for the respondents.
may I pray, my lord, let it be listed next week, my lord. Because
Let
there's
this-
a-
That's why 1 week.
Oh.
Let this matter be listed on, after a week.
Your Lordship, till the next date, let the interim be continued.
Yes.
Item number 17.
My lord, during the pendency of this case, my lord, charge sheet matter has been charge sheeted, my lord.
Ah.
So let them come with affidavit, your lordship, bring into record the charge sheet, madam.
You file that order is required or no? No order is required.
It's up to them, your lord.
Ms. Swenso, counsel for the petition submits that she may be granted 2 weeks time to bring on record the charge sheet. As the, this has already, has filed the charge during the pendency of this petition. Sir, here, the non-medicine people, they are allowed this up to 2 weeks.
And your lordship, TCR may also be called for.
So as to enable the,
Scan copy.
then counsel for the petitioners to, when that will be the application, bring on record the charge sheet. Listing. call for a scan copy of the charge.
TCR. Yeah.
List after 2 years.
Deeply applied.
Item number 18 and 19.
Lord, this is yet another case. I'll be requesting your lordships for final disposal. Now, my lord, the case is that your
Affidavit has been filed.
yes,
my lord.
affidavit
There
has-
is a interim order. That's why we need a.
Next week.
My lord. Since
my lord, my only request would be if the government has their file with them, it will be better because what happened, my lord, the executive order was passed by the governmental authority. Now, after that, my lord, the chief engineer has passed some order saying that not the 6 bridges were given to them for construction, only 2 bridges. Sometimes he said 1 bridges, sometimes 2 bridges. Now, these are the condition, and now whether the order passed by the chief engineer is in terms with Article 166(3), there's the question involved. So therefore, record to that effect will be necessary. And further, my lord, they issued a corrigendum, my lord, modifying the entire process.
You have the records.
no, my lord, if record, my lord, our affidavit will suffice, my lord.
No, because I'll be relying on, my lord, 166(3). So therefore, unless they produce the records, my lord,
List after 2 weeks.
My lord, there is
What-
an interim order. That's
What
why
is interim? 1 week.
we are unable to go ahead, my lord, with the developmental work.
We'll see the record
my lord, it's an interest for
next week. Next week.
just 1 minute.
Or Mr. As the
That-
senior counsel assisted by
Mr.
Mr.
Tara.
T.T. Tara, counsel for the petition. What is the matter? This construction.
My
of
lord,
road-
yes, my lord, they were given a work for construction of road. They have completed their work, which was in the tender. Now there are 6 bridges, new set of works, my lord. They want to construct these 6 bridges also without any tender, saying that it is an extended tender part of the construction of the road.
Lord, I'm very sorry, the fact is not that.
They want it,
Your lordship, look at-
earlier tender was for an amount of 69 crores. Now this is a tender amount of 80 crores, my lord. They want this without an,
Your lordship, just have a glance.
without
at
any
page
tender.
67. That will make the entire picture clear.
Where bridges are to bear. They have completed the road.
They have completed the road. The road work was for 69 crores. Now 6 new bridges are to be constructed. They want to construct these bridges. This,
You have issued a tender on it.
no, we wanted to issue the tender, but there is a stay order, madam.
Where is the stay order?
My lord, can your lordship see at page 67?
Just wait. Where is the stay order?
The first, my lord, order, my lord.
Status quo order was
Status
passed.
quo order. We are unable to go ahead with the plotting of tender. My lord, therefore,
Next week.
if this could be heard, my lord.
Next week.
My lord, we are also very,
Produce the record.
the record will be very much necessary. My lord. Otherwise, after arguing for 2 hours, my learned friend may
Yes,
say,
they will say
Then can it be on 11th, my lord?
11.
11th November.
Or Mr.
my lord, can it be on 10th? My lord?
10th.
Is the so and so, and also on Mr. N. Ratan London against London Networking Gallery. Although the affidavit, although Mr. London and Ratan London Edition Advocate General expressing urgency in the matter, submitted that this the affidavits have been filed. Mr. Dr. London Senior Counsel submits that the view of the nature of the issue involved, the record shall be necessary. Considering above, as agreed to by, no, considerable that the record be produced by the state. As agreed to by London Council to the parties, let this method listed on 10th.
My lord, status quo order may continue.
interim order of status quo shall continue till the next day.
Records be called.
Huh?
Records be called.
I said produce.
My lord, a record containing the corrigendum order.
You enter the record.
Yes.
Produce
Yeah, entire record.
Obliged.
Matter number 20 to 22. My lord, before the land senior starts, my lord, we will be required some more time to file the affidavit. I think, my lord, GST, they have filed the affidavit. Only they left out is the state.
My lord, can we pray for 24th of December, my lord? No, November, sorry.
November.
That's a Monday, my lord.
Heard Mr. Ken Chaudhary.
Here, another mistake, criminal mistake is relating to some that may be also.
Also, that can be take together.
Heard Mr. Ken Chaudhary, learned senior counsel assisted by Mr. R.M. Deka, learned counsel for the petitioner. Petitioners will list, same order, one order will, common order.
Common order.
And Mr. Arisnabo.
Jessica.
You are one.
And for.
Respond number.
GST authority.
One. Respond number 1, 2, 3. Okay, SCK. For respondent. Standing counsel GST. CGST. And Mr. Arisnabo. No, please stop. On the prayer of Mr. Arisnabo, additional for the state, again for the state. For the 3 weeks, 3 weeks, we'll say 3 weeks time is granted to file.
Look, we are praying for 24th of November.
As agreed to by learned counsel for the parties, let this matter be listed on 24/11/2020, along with criminal petition.
Criminal misapplication number 5 of 25.
5 of 2020.
And my lord, item 35 of today's list.
And
that's a contempt matter.
35.
Yes.
Contempt case 25 of 2020.
And my lord, interim orders will continue.
Interim order passed earlier will continue.
Deep.
Matter number 23.
Uh, 23 and 24, can this be passed over, my lord?
Time being.
For the time being. It may be taken up after the bail matters, my lord.
Not after the bail matter. All other matter.
Okay.
Matter number 27.
Yes.
Lordship, today also, Lordship, the applicant counsel is absent, Lordship. We have case diary, Lordship.
What does anything?
Yes, Lordship, because Lordship, he is not, after Lordship obtaining the interim protection, he is not appearing before the IO for the
It's okay,
statement.
that you have submitted last.
Yes,
occasion.
Lordship.
Are there any materials against the accused?
Yes, Lordship, material is there, Lordship. And he was, Lordship, reportedly he was being issued notice to appear, Lordship. Again, Lordship, after issuance of appearance, Lordship, he appeared before this honorable court for the protection, Lordship. Thereby also, Lordship, he did not appear. He was, Lordship, interim was granted on 3/9/25, Lordship. So it's humble fear, Lordship, that interim may be vacated, Lordship.
This bail application has been listed today after having considered that none appears for the applicant on consecutive 2 days on 21/10/2025 and 23/10/2025, providing an opportunity to the applicant, Mr. Next para, as submitted by Mr. MSL Hagan, London Edition PP on 23/10/2025 to the effect that despite the direction to appear before the investigating officer within 5 days, while granting interim bail to the applicant, accused applicant, he has failed to appear as on today before the investigating officer. Mr. Next paragraph. Considering that the applicant accused, after obtaining the interim bail order on 04/09/2025, has remains unrepresented, and considering that he has violated the condition of interim bail order that is 04/09/2025, the interim order passed by this court on 04/09/2025 is hereby recalled. List the matter after a week.
Matter number 28. Your Lordship, the item number 28 and 29 is connected with the same FIR, number 83 of 2025. Your Lordship, here this is the illegal arrest because there is no remand, transit remand has been taken by the prosecution to arrest my person from the Assam. Okay, and number 2 is the illegal detention also because there's after the arrest, the magistrate also not checked or verified from where he was arrested. And the prosecution which had the allegation for the criminal breach of trust. Your Lordship, here the ingredients of the criminal breach of trust, the entrustment is lacking because I am not an employee, I am not a partner, I'm not connected with the complainant. So I don't know how they had made the criminal breach of trust. So Your Lordship, this is the matter. So Your Lordship, means I just want the bail in this matter. And I just, this application is regarding for the bail. So
I've seen it. It's for bail.
Yeah.
Yes.
So this is the 3.
I think the grounds which you have taken.
Yeah.
In fact, better you file a criminal petition.
Yes, sir.
On that criminal petition, you may seek bail in the interim. Then we can consider that.
But Your Lordship, this is they had not even.
No, that's the grounds you have pointed out, or you have made it about.
Yes.
It's not simply a case for bail.
Yes, Your Lordship. So I'm just once for the bail, but I just highlight the matter which.
No, that is the ground. Why it should not be granted bail? Yes.
Lordship, regarding the Lordship transit, Lordship, that Lordship, during the Lordship
You are arrested in Assam.
Assam, Your Lordship, the Harmothi. In the Harmothi, they had arrested me, and they had not informed the local police authority of Assam.
Lordship, or Lordship, legal formalities was Lordship carried out Lordship in the case study Lordship, it is reflected that.
Then that's what I'm saying. That some other grounds you have to say. If they say that if its record reveals as formalities in accordance with laws.
Just in the page number 24, there's the place of the arrest. It's a near outpost of Harmothi.
It's all right, yeah, maybe. But then, what do you say? Arrested in Harmothi in Assam?
Lordship,
have you followed the provisions?
Yes, Lordship, as per this case study, Lordship, here, Lordship, it is reflected that the further proceeding was, Lordship, or legal formalities was observed, Lordship.
Not simply saying will not do. What had happened? In consonant with that, you have to show some records that he was arrested in Assam, and then the remand and all those things, transit bail, all those things had to be
Then Lordship, 1, 2 days may be given, Lordship, so that I'll,
Lordship, this matter
Because
was.
you are simply saying will not do, no? Simply, what you are saying, your record says that police is saying that legal
Yes, sir.
formalities has been complied with.
Yes,
That's
sir.
all.
yes, Lordship,
That is a statement,
yes, sir.
but it has to be shown whether that is done or not. But I doubt. I don't know, subject to what you say.
No, Lordship, it is
This
on the,
should be a
on,
criminal.
it is
Your
on the
ground
record,
not
Your
to
Lordship,
be
in the
criminal.
arrest memo, it is given, Your Lordship, in the place of arrest is
Page,
it's 24, Your Lordship.
yes.
Is a date, place of arrest. Is a number 5th column.
Page 24.
Yes, yes.
Page 24 doesn't say anything. This what? Which petition you are?
Is a arrest memo.
Which petition?
Santoshi,
123.
Santoshi Rai, Your Lordship.
123. You are referring to page 24.
Yeah, sure. It's a arrest memo.
In page 21, Lordship.
Page 24 is something different. Yes, 22.
Is a arrest memo near outpost of Harmoti, Your Lordship.
Arrest map. Page 21.
Is a
Place of arrest
yes, yes.
near outpost Harmoti.
See,
So-
the Harmoti is in Your Lordship in the Assam, and they had arrested there, and they are not informed the local police authority.
Harmoti is also outpost of what?
Also. Assam, Lakhimpur district, Your Lordship.
Okay. Arrested by whom?
Arrested by Your Lordship, this SI BP Singh.
PS Naharlagan.
Yes, yes.
Lordship, in the case study, Lordship, it is observed that they arrived at Almuti and arrested both the accused, Lordship, C. Bharatur Solan Arabidas from there after coordination with the ICOP Harmoti and also observing all legal formalities.
But there's no record on this, because whatever the record that they have submitted in the court, there nothing is there, Your Lordship. Transient or transit remand is there. Nothing is there. Whatever the prosecution say, we don't have on records, Your Lordship. If she have anything else, then you have to show to the court that there's a formalities has been done.
So what's the procedure? What is the procedure?
Because whenever they arrest, they have to inform the local police authority, then they have to produce the arrested person before the local the court.
So what is the offense?
But there is a criminal breach of trust, which the allegation was there.
Misappropriation.
A criminal breach of trust, Your Lordship.
And
but
misappropriation.
Misappropriation, but my person is not a business partner, not a director, not a family member. No, there's no connection between the person who was arrested, the petitioner, and the person who has complained.
Accused name is who?
Is Ravi Rai.
Ravi Rai.
Ravi Rai, and in the second number, it is Harka Bahadur Sunar. And
what is your role?
They are not connected.
Misappropriation of what?
They say that means his GST number was misused.
It's all.
GST number was misused and password. But Your Lordship, in the GST, I just want to take Your Lordship.
Connection with this, there's any order passed by this court in some other cases?
No.
I think there is.
But Your Lordship, I just want to take Your Lordship 2 seconds. The GST, whenever we use the GST password and user ID, there is a OTP which comes to the particular person.
It's okay, we'll go into that. Is there any order passed by this court? I mean, the maybe coordinate bench, the High Court, relates to this matter.
Your Lordship, this matter was listed before this Honorable Court on 26th, when the court was called the CD only, before the vacation, Your Lordship.
Is there any other
no, nothing.
co-accused?
No. Nothing, Your Lordship.
No other co-accused?
No. The case, only two person was there. So one is Ravi Rai and second is the Harka Bahadur Sunar.
What is your role? Why you are saying that you are not involved?
Because I am not the partner. I have not a,
Is there a good
there's no
office
connection
request
between
to
me
lodge
and
for
complainant. Your
So and so, Sri Harka Bahadur Sonar, alleged to be resident Harmoti, financial fraud, prudently accessing into my. This is by whom? Raja Parang. Huh?
Yes.
No, the question of business partner. Ravi Rai.
Ravi Rai.
2% so and so has made fraud transaction using my GST ID password without any my knowledge. Transactions made against my farm sales interest on the account of so and so this fraud transaction only they had net fraud will sell in. Yes, what is anything?
Lordship,
The investigation.
yes, Lordship, during the investigation, Lordship, other witnesses are also been examined, Lordship. In their statement, the two persons' name was revealed, Lordship. They have
Any other materials?
Lordship, that's why, Lordship, now more witnesses, the recording, Lordship, statement is still pending, Lord. And Lordship, in the Lordship,
When they were arrested?
they have.
Your Lordship,
they arrested-
they are arrested on 3 September and already more than 50 days, Your Lordship. 3rd September.
September, October.
Yeah. Already more than 50 days, Your Lordship.
Statutory period not over.
Huh?
Not over.
No. They're still on the behind the custody.
When you are going to complain? When you are doing the statutory period will over? Is it 60 days or 90 days?
Your Lordship is already a illegal arrest, Your Lordship. We just come.
I'm asking, is it 90 days or 60 days? Statutory period?
60 days.
Sure. Are you sure? You flagged the, what is there? Any materials you flagged it? Heard Mr. So-and-so, learned counsel for the.
Amrit Singh.
Amjad Singh.
Amrit Singh.
Huh?
Amrit Singh.
Amrit Singh, learned counsel for the petitioner, and also had MS Elhagen learned edition PP for the state. Decision bail application, huh? So-and-so, so-and-so. You take this, pass the order in the chamber. I'll pass the order. I'll go through the case diary. But your grounds, this is only ground.
Yes.
There's a violation of the provisions of law while arresting.
Yeah.
Therefore, it's become an illegal detention.
Illegal arrest,
Illegal
detention,
arrest,
and the criminal breach of trust.
Which this court is not not impressed. Any other ground?
And the criminal breach of trust was the allegation they made.
That will not go into. It's under investigation.
Okay.
So most likely, bail may not succeed for a time being. But I'll go through the case diary.
Okay.
All right. Okay. Most likely, may not.
Item number 30.
Because your grounds, this court is not impressed. Cannot be ground, but subject to case diary.
Okay.
You are not pleading any other, you are not submitting any other ground except for this.
Yes, this is only two. Your Lordship, in this item number 30, we are just, I'm not going to the merit of the case. We just say that the prosecution is taking too much time for the witnessing, getting the witness.
Your Lordship, the record is yet to be received by the registry.
Yes.
At the Supreme Court also.
Amrit Singh.
Yes, Your Lordship.
Counsel for the applicant. MST edition PP submits that record is yes, trial court record is yes to be received. Okay. Therefore, press for listing of the matter after a week.
Yes.
After 2 weeks or
2 weeks.
2 weeks.
2 weeks.
After a week, Your Lordship.
Supreme Court has granted bail to
Yeah,
the
Supreme
main-
Court has granted to the main accused, Your Lordship, on the ground that because the prosecution is taking too much time. So on the same ground only, I just want to.
There's no way out.
Yes.
On parity or your Supreme Court has always granted the only.
This is the order.
I think I've seen it.
Yes.
It's just looking at the record will be a mere formality.
Deeply.
I would like,
Why not 1 week? You want to stay there for another 2 weeks or what?
Actually, we want the bail as soon as possible. That's, thank you. I would like to.
2 weeks. You want to stay there.
Matter number 31.
We have not received this case study yet. Lord.
Go chore. Cow theft. Yeah. And Mr. B type with the learning council for the applicant, huh? Same order. 31, 32, 33. MS L Hage learned addition petition step CGF to receive the case diary. Case diary. When?
Lordship,
30th,
31st, Lordship.
31st.
Obliged.
Matter number 32.
32, 33, 34. No, same. Sorry.
Matter number 34.
What do you call it? The stealing of cow. Don't steal.
Kindly please, Your Lordship. Lordship, this application has been filed for restoration of criminal petition number 72 of 2025,
Yes.
which was dismissed by this honorable court on 13th of August 2025. The order is at page number 14 of the application.
14.
Yes, Your Lordship. Out here it is mentioned that none appears on behalf of the petitioners on call, while so and so and so. The record reveals that on earlier occasion, also on 7/8/2025, the petitioners had remained absent. It appears that the petitioners are no longer interested to pursue the matter. In view of the above, this criminal petition stands dismissed for non-prosecution, Your Lordship. Your Lordship, my reasons for restoring this application is, first of all, is the criminal since it was a criminal petition, it could not have been dismissed on the ground of non-prosecution. Second, it is also because the councils could not be present on the
Please.
the council for the petitioners could not be present on the set dates because I personally was absent on 13 because I was out of station and I had engaged one of my junior associates to appear. However, we could not be present on that day. And this criminal petition was filed for quashing of FIR on the basis of mutual settlement. And since it was a family matter.
There's no, it's not a statutory appeal.
Yes, Your Lordship.
Therefore, saying that could not have been dismissed for non-prosecution of the criminal petition may not be correct.
Yes,
It is
Your
only
Lordship.
in case of a statutory appeal or the petition. It's a, you are seeking to invoke the inherent power of the court.
Yes, Your Lordship.
It's up to the court. So,
No, it could have been for
in a
non-appearance.
strict sense, it is only in case of a statutory appeal or the petition or application that cannot be dismissed for non-prosecution, right?
Yes, Your Lordship.
Is not it?
Yes, Your Lordship. My
The
humble
criminal
prayer-
petition is filed seeking invoking of the inherent power of
Inherent
the
power.
court, which the court may not refuse also.
Yes,
Is
Your
not it?
True.
And on top of that, there is no law, perhaps, that the criminal petition filed under 482 cannot be dismissed for non-prosecution.
Yes, that there is no such law.
And number two, since you might have engaged your colleague, if he should, if he or she has chosen not to appear, how can we do? How can help you? It is
Your Lordship, I'm merely submitting that because of the mistake of the council, the petitioner should not be made to suffer. Since this petition was
Maybe.
filed for the quashing of FI, which was already
Yes.
settled.
Yes, Lordship, rectified out that.
Any objection? No objection.
Before that, Lordship, there is no clear she is not invoking any provision, Lordship. Just file up application.
What is the provision?
Lordship, at least
Should have been under 528. That is the only provision. 528 BNS and 482 CRPC, which was.
So he said that no, the provision has been mentioned.
Your
For
that
filing
implies-
this case,
Yes, Lordship, and she mentioned that there is 40 days of delays also.
I have stated my reason on the last paragraph. Your Lordship.
Only stating that
Because of-
she was in Guwahati on.
if there is
The
a
thing is
delay,
that
if there is a delay,
I have specifically mentioned it in the petition that there is a delay of 40 days
in filing
Because-
this application,
in filing this application because.
I think is
we
it not
came to
required
know-
to file? This is a miscellaneous case.
Yes, Your Lordship.
It's a miscellaneous case.
Yes, Your Lordship.
Do you, don't you need to file any condemnation petition if there is a delay?
Your Lordship, if the reasons are stated in the petition, the court may allow.
Hmm?
If the reasons are mentioned in the petition itself, also the court usually allows.
Cannot ask everything from the limitation. Limitation. Yes,
If Your Lordship requires me to file another IA, I will do so.
it's not me requiring you, it's the law and the procedure which
That is
you have
why,
to
Your
follow.
Lordship, I have mentioned it specifically in para 6 of.
No, no, that will not, is it permissible? What is the limitation of filing?
Limitation is 30 days
Or for what? Of what?
for challenging any orders before the High Court. Under Article 170.
Yes, PP sir, what do you say?
Lordship, this is in fact not maintainable, Lordship.
Why?
I have also a authority of Lordship, Srimati Sarosh Rajna in others, Lordship, wherein the deliberate attempt of breaking the court.
No, don't so, just immediately like that. Is there any delay? Why are you saying that there is a delay in filing the miscase? Madam?
Lordship, because the orders should have been challenged within a period of 30 days.
Wait, under what provision? Which provision?
Limitation Act 122, Article 122. Article 122 of the Limitation Act.
To restore or shoot or deal or
Within 30 days.
No, not leave it to me. What is the limitation, sir? Is there delay? Will this 122 will apply?
If section 482 of CRPC, which is now 528 of BNS, if that particular section is invoked, then in that case, the limitation period will not be applicable, Your Lordship, in my humble opinion.
Why?
Because it comes under the inherent powers of this honorable court. And
No, we're on
any other application.
we're on the restorations. Now we're on the restoration.
Yes, Your Lordship. According to this Article 222, if we go according to that, then the period of limitation will be 30 days.
Is it not in the civil case? It also applied to criminal petitions, criminal applications.
Yes, Your Lordship. According to the section.
Yes, madam. It's okay. What do you say? Very small, but then both of you and Mr. Tara also. It's a very small, yes.
In my humble opinion, so far as invoking inherent powers of the court is concerned, there is no statutory period of limitation. So therefore, coronation of delay does not arise.
No, this is for restoration for this default.
For restoration, there is, but
Yeah.
again, under the criminal laws, there
That's
is
what
no.
I'm saying.
Yes.
This is restoration, the application is restoration of the petition dismissed for default.
Yes. I don't think there is any provision for dismissal for default in criminal case. It is not there. At least I have not seen any provision.
No, but while invoking inherent power, that is 528 now in the DNS.
No, problem is the court has dismissed the petition, criminal petition for want of prosecution, or that the petitioner may not be interested.
Yes, in fact, Lordship, regarding this specific issue, I had gone through one judgment in which, in such cases, this kind of application was filed and the court allowed it. Of course, I don't have the citation right now, but.
We'll see, let us the things clear. You also, you just help,
Because,
help them
because
out.
in such cases, there is no other remedy.
You just assist them, we'll list it after two or 3 days. Because according to me, unless is the statutory appeal or application, since the dismissal is of criminal petition seeking inherent power of this court, I mean, perhaps there would not be any bar to dismiss for default, whatever, for want of prosecution. Number one. Number two, for filing a restoration petition in a criminal petition, can this Article 122 be made applicable? These two things kindly. That's why I said, let us learn together. So and so, learn counsel for the future, and Mr. So and so, learn counsel for the learn PP for this. List the matter. On 30. Can you take help of this? Then council, huh?
May I please, Your Lordship? Sorry for interruption, Your Lordship. My item was 27, Your Lordship. But due to technical fault, I was not able to join at appropriate time. For that, I apologize, Your Lordship.
Yes.
Lordship, my item was 27, but due to technical fault, I was not able to join at appropriate time. For that, I apologize.
You come physically, we'll hear you. We're fixed when this item 27? After a week, we'll see.
Lordship.
You are in on interim bail. Are you in
Your
on
Lordship.
interim bail? Next
Yes,
week,
Your
we're
Lordship.
fixing next week. You come physically, it's very difficult.
Lordship. Lordship. My appearance may be marked, Your Lordship. If
You just say. Mr.
BJ Das for MM Zaman.
BJ Das for MM Jaman. You said on the prayer of so and so. Mr. BJ Das, learning concept for MM before applicant. List this matter after a week. Item 27.
Item number 35.
Yes.
What's it? Service report or
And Mr. K. Learn concept for the petition. Petitioner. Petitioners? Yes. Award service report. List after 3 weeks.
Item number 36.
Yes, my lordship. Today, actually, matter was listed for this year. Whether they have gathered or not, we don't have any idea. And I have not given any stay or a variance for the suspension of the case.
Yes.
This is a criminal application I have filed.
Yes.
482 and
Today
528.
listed for what? Trial court record not yet.
For quashing.
We'll send reminder. You have to. It will be through the registry.
Yes. Yes.
Heard Mr. So and so learned concept and Mr. Deloy learned public prosecutor for the state. Office note indicates that trial court record is yet to be received. Registry to send reminder. List the matter after 3 weeks.
Until then, my lordship,
Sir, that
proceeding may be kept in abeyance, my lordship.
We'll see.
At least abeyance. I have no interim order or nothing is there.
You could have prayed that day.
Yes,
when the matter was,
I have prayed.
but it was
raised before this honorable court also.
It was not considered.
My lordship, if it is
We'll
considered,
consider on next day.
my lordship,
When it was not considered at the beginning.
next date is coming on 8th of this month only, coming month. So therefore, like I may be given.
List a matter on 7.
Yes. Yes, my lordship.
Item number 37.
May I please, Lordship? Lordship, kindly see if the interim order can be Lordship modified or if vacated, Lordship.
Why?
Here, Lordship, the case is Lordship regulations of petitioner is serving as a contingency in the labor and employment department, Lordship. If Lordship see the recruitment rule, Lordship, rule does not recognize Lordship regulations of service.
No, sir, this is listed for orders today. You have not filed anything for modification.
Yes, Lordship.
Your service reports will wait for some time.
Lordship,
If you are aggrieved,
one more thing, Lordship.
if you are aggrieved, you file an appropriate application, we'll consider that.
Actually, Lordship, the interim is till today, Lordship. So therefore, Lordship, I would like to apprise this, some facts, Lordship.
No, it's okay. Not
Because exam is, Lordship, already.
Why not possible to consider today? This is for till the next date, the process for selection appointment to the post of driver.
Yes,
This
this is a common examination law.
Sound to be available in the labor and employment department shall be remain.
Earlier lawship, the same writ petition was filed lawship, and that was withdrawn, and lawship this press petition has been filed. In that petition lawship, everything is same. Only APSSB has been implemented lawship in new petition lawship. In that case lawship, earlier writ petition lawship,
That was withdrawn.
that was withdrawn. There also an interim. In interim itself lawship, it will be subject to outcome of the writ petitions. Selection process was not state lawship.
When is the selection process?
Lawship.
When is the, it's likely to?
The 7th of December lawsuit. 7th of December lawsuit.
It's okay.
And this is common selection
You
process.
file the affidavit.
Lawsuit
File
just
the affidavit.
instruction has been received lawsuit.
So you file it. 7 December, long way to go.
Lawsuit, this is a common selection process.
Enough time, yes.
And lawsuit, the process also has been lawsuit installed lawsuit. Selection process and appointment both have been lawsuit installed lawsuit.
Who is respondent number 4 and 5?
Lawsuit, I'm APSSB lawsuit.
So you file it, will immediately dispose of the matter.
Lawsuit,
This,
basically,
your office report indicates that
APSSB has a limited role lawsuit. Whatever requisitions come to them lawsuit, they have lawsuit advertised lawsuit.
who is the other respondent?
Labor Department lawsuit. Instruction has been received lawsuit.
What about the NPCs? 4 and 5, it's only for 4 and 5.
4 and
File the affidavit and appropriate application, we'll consider.
lawsuit.
Or Mr. So-and-so said. Learned, although the office note dated 24/10/2025 indicates that service report in respect of respondent number 4 and 5 is still awaited. However, Mr. Estafil Learned Senior Government Advocate submits that he would be appearing on behalf of respondent number 4 and 5. This to accordingly service report. Service notice, service is complete. Respondent may file their affidavit.
Lordship, till next date.
This after 2 weeks.
After 2 weeks.
2 weeks.
Lordship,
If a date can be fixed,
First earlier still continue.
if date can be fixed,
After 2 weeks,
10 November.
10th November.
Obligation.
Item number 38.
What is this?
May I please your lordship?
What is this? By whom?
My lord, I have filed my power today on behalf of.
Where you are getting this?
May I
Yes.
please your lordship? Lordship, I am for the petitioner, this writ petition. There
You are
has
for
been,
4 to 9.
4 to 9, yes.
Okay.
I am for 4 to 7.
Huh?
WPC 4 to 7.
No,
Respondent
he's
number 4.
appearing.
Yes, my lord.
Her MS so-and-so learned
As
contact for
may
the
be.
petitioner. Mr. This learned counsel enters appearance on behalf of respondent number 4 to 9.
4 to 9.
4 to 9, please. Accordingly, services, you are for?
I'm appearing on behalf of NSDG and Mr. M. Kato for respondent 1.
Please, accordingly, services are complete.
My lord, the service report is awaited.
He is appearing. He is appearing.
4 to 9, I am appearing for 4 to 9.
Okay.
But just
Okay.
there has been some subsequent development, otherwise, more or less, this writ petition has become in project because the petitioner, he has already been transferred from that project site.
Have you got any instruction?
Yes,
Do you have any
lordship.
instruction?
Yes, lordship, there has been subsequent developments.
So, it's a matter is what? Transparent.
My lord, it's regarding some incentive because this is regarding some hydropower projects that is being constructed in Dibang Valley district. Now this company, that's SJVN, yes, it has been interested with that work, construction work. Now that company in the year 2023 came up with some incentive that persons who are transferred and willing to work there in Arunachal, because since it's a hard location, some incentives are given. Some
Okay, you
special.
file affidavit, we'll see.
Lordship, we have filed an additional affidavit.
You served to him also.
Yes, my
Have you
lord.
served?
And one
Have you
thing more,
received
my lord, this honorable court was pleased to pass an interim order directing the
We'll
respondents.
continue that. Let them file the
Of
affidavit.
11/7.
Since he's appearing today for the first time.
Yes, my lord.
You shared you furnished a copy of the additional affidavit also?
Yes, my lord.
Okay. MS so learned counsel for the petitioners to furnish the copy of the writ petition. Have you received the writ petition?
Yes, I've received.
Furnish the copy of the additional affidavit filed by additional affidavit filed on behalf of the petitioner. Please stop. During the course of the day. You
Yes, my
furnish it
lord.
today. Is spread for by the. Have you filed? All of you have. Are you required to file?
Now you're lordship.
You record their name and.
Main
First time
respondent,
is
contesting
straightforward.
party would be 4 to 9 only, basically.
As spread for by Mr. Soki, learned counsel for respondent 4 and 5. 2 weeks time is granted to file affidavit.
Let it be 4 weeks, Mala, since it's
4 weeks.
from Delhi.
4 weeks. Interim order passed earlier shall continue. Is there interim order?
Yes, my lord. My
Saying
humble
what?
prayer is that interim should be continued.
No. What interim order was there?
My
What
lord,
is the interim order?
I was serving as a GM and I was transferred to Bihar Buxar as a DGM. I was demoted and transferred.
What is the interim order?
Interim order was to keep me as a GM only.
In
my
the
lord.
next day, the interim order shall not be given effect to insofar as there is. No, we'll say interim order passed earlier shall continue. That's all.
They-
All right.
Item number 39.
my lord.
Difficulty.
Yes, your lordship.
Difficulty.
Yes, your lordship.
We wanted to give you what is that? Non-practicing allowance.
Yes, your lordship.
Immediately from 2016 till your retirement.
Yes, your lordship.
You don't want.
My lord,
Okay.
can it be?
Although MSD Tamuk, although this court is willing to grant relief to the petitioner, MSD Tamuk has refused to accept. Therefore, list this matter up.
My lord,
I'm
can
sorry.
it be listed on Wednesday, your lordship?
On the prayer of MSD Tamuk, learned counsel for the petitioner, on the ground that Mr. Deepang, leading counsel in this matter in this court. Come on, list this matter after
My lord, can it be on
after 2
Wednesday,
weeks.
your lordship?
After 2 weeks. Mr. N. Rather Learned Addition Advocate General is present. I'm just on the lighter note. Since it has been listed and I have gone through the brief, listed for hearing,
Yes.
final hearing. So this court is not inclined to adjourn because I have gone through the brief. I've taken the pain to go through the brief yesterday evening, so I don't want to adjourn this. I was not inclined, but if it's indisposed, okay.
Item number 23, unlisted, it's a pass-over for the timing matter.
23. Here and 24.
Yes, my lord.
Different place.
Same constituency, my lord. One is at Paying, the different city blocks, my lord. Different city blocks.
But the grounds are same.
Grounds are same, my lord.
Can be disposed of together.
My lord.
Differently.
Yes, my lord.
Yes. We'll complete before 1 o'clock. Is it possible?
Yes, it will be possible, my lord.
Yes.
My lord, I am challenging the eligibility of the respondent number 4, my lord. In NIT dated
What is the NIT?
NIT, my lord, you'll find at page number
32.
32, my lord.
Yes.
My lord, may I read it? May I read NIT, my lord?
It's okay. Supply of material under Manrega so and so.
So-and-so.
Any relevant clause?
No,
clauses
my lord,
like
the project director so-and-so, Government of Arunachal Pradesh, invest supply so-and-so from APPWD, CPWD, BRO, BRF, APWD on appropriate categories of class 2.
Class 2, yes.
Domicile within the jurisdiction of
assembly constituencies shall be governed by the Arunachal Pradesh district-based entrepreneur and professional.
So according to you, the respondent number 6
Yes, my lord.
is not a class 1, class 2.
No, he is a class 2 contractor, my lord. But this NIT will be governed by the Act of, the 2015, my lord.
And he is not a domicile within the Jurisdictional Assembly constituency.
No, he is a domicile, my lord.
Then
But then, my lord, if my lord comes to the Act, my lord, 2015
shall
Act,
be
my lord,
governed by Arunachal Pradesh district with Then
Arunachal Pradesh, it provides that
so he's not a registered contractors,
he's not an enlisted contractor, my lord.
registered
No, he's registered, my lord, but he's registered in Assam, my lord.
and not a enlisted contractor.
Yes, my lord. Under the rules of 2008, my lord.
Under rules of
2008, my lord.
rules of what is this rule?
Contractors Enlistment Rule 2008. my lord.
Where it is? Where it is?
Lord, I'll just. Yeah, it is in the Act itself, my lord.
Come to the Act 2015,
Yes, my lord.
page 68. Have you typed it out? Is there any typed copy?
No, my lord, no, my lord. If my lord comes to page 69, my lord. In the Act, my lord, 2015 Act, my lord, clause 4, subclause 2A, my lord. May I read it, my lord?
Yes.
The contractor,
This is clause 4.
subclause 2, subclause A.
Schedule.
Yes, my lord. After the schedule, my lord.
After schedule what? 2.
Subclause 2, subclause A.
Clause 2A.
Yes, my lord.
Yes.
The contractor, entrepreneur, before participating in the tender
Must satisfy the following conditions.
Yes, my lord.
The provision must
be duly registered under the Arunachal Pradesh Contractor Enlistment Rules 2008, my lord, in the appropriate class of category, and that the registration must be valid on the date of participation of the tender, a copy of which shall be submitted in the tender submitted to the tender authority, my lord. Now, meaning thereby, my lord, any contractor, he might be registered under any works department, my lord. Whether it's in Assam, whether it's a BRO, whether it's the MES, my lord, but then he has to be enlisted in the Arunachal Pradesh
Contractors Enlistment Rules.
Yes, my lord.
Okay.
That is
That is number 1.
Yes, my lord.
Number 2.
No, I'm coming to that, my lord. One by one, my lord.
So that's where 1 is over. 2. Come to 2.
The point on main issue, my lord.
Yes.
And the other issue, my lord, if my lord turns to, before that, my lord, if my lord comes to page number, special conditions, my lord, of the tender, my lord, which starts from page 44, my lord, at page 45, my lord. It is a part of the tender document, my lord. Page 44, my lord. Clause 13, my lord. May I read it, my lord? Clause 13.
Yes.
The tenderer must produce the following documents and furnish the original copy of the documents while submitting tender papers and during opening of the tender.
Which clause?
13, my lord. 1-3.
Page 40.
45, my lord.
Yes.
Now it's serial number 9, my lord. Down below.
Solvency certificate.
Solvency certificate from a nationalized bank, not less than 50% of the tender amount, my lord. Now here, as far as the respondent number 4 is, the private respondent is concerned, my lord, he has submitted a solvency certificate from a scheduled bank, my lord, not a nationalized bank, my lord. That is one of the issues, my lord.
Scheduled bank.
Yes, my lord. It has to be from a nationalized bank, my lord.
solvency
certificate, my lord, or the bank guarantee or the solvency certificate, my lord.
of R6. Not from nationalized bank.
Yes, my lord.
Why? Why not nationalized bank?
My lord.
Why not nationalized bank?
No, they have to submit it from the nationalized bank, my lord.
What is this solvency certificate? From which bank?
From ICICI bank, my lord.
ICICI is not nationalized.
No, my lord. Now, my lord, before going forward, my lord, I may turn back to my lord, page 34, my lord. I just missed it, my lord. Page 34, my lord. Item rates are invited on behalf of Government of Arunachal Pradesh from registered and eligible contractors of appropriate class enlisted under the Arunachal Pradesh Contractors Enlistment Rule 2008, my lord.
This is what?
This is the condition of tender, my lord. Tender document, my lord. NIT, my lord. This is one of the provisions, my lord.
That you have said so.
Yes, my lord. But specifically, this provided in the.
You are registered contractor.
I'm a registered contractor. He's the private respondent is not, my lord.
No, see, these are against the respondent number 6.
Yes, my
What
lord.
about you?
I'm fine, my lord.
Huh?
I'm registered, my lord. I'm a domicile of Talia, my lord.
No, why you have been rejected? First, you challenge. Are you challenging your rejection?
Yes,
You
my
are
lord.
technically found to be what?
Yes, fine, my lord.
Only financial.
No, financial also I am fine, my lord.
Financial, you are L1, L2.
Both are L1.
Huh?
Both are L1.
How is possible?
Therefore, my lord. Both are L1, my lord.
So you have no issue. You have.
No, I.
Why you have been rejected? Why the respondent 6?
There is no ground as such, my lord. No ground has been.
Why any rejection?
My lord.
Any rejection?
No, my lord. There is no ground as such, my lord. The tender.
See, other day we find that in some other tender,
my lord,
nobody is talking. I mean, the petitioner is never making any submission on the rejection. Ultimately, we find that there was a rejection which was communicated.
No, it was not communicated to me, my lord. Now, the tender. I'll come to the tender evaluation committee. That both of them has been declared.
Now, why you are challenging it?
Because, my lord, the private respondent is not eligible at all, my lord. Once he is not eligible, my lord.
About him will come later. We have heard you on this.
Yes, my lord.
What about you? Why you have been rejected?
There is no ground as such, my lord.
Is there any formal rejection?
No, my lord. Nothing, my lord.
How? I don't know. You reach up to financial.
Yes, my lord. And both
financial bid was also open.
The tender evaluation committee has declared both of the. There were, 3 participants, my lord.
Let us see. What is the decision?
My lord.
Technical, no issue.
Financial also no issue, my lord.
Technical, no. Financial, technical. There were three bidders.
Yes, my lord.
Out of 3 bidders, 1 was rejected.
In the technical.
Bid.
My lord.
Technical bid was rejected of the 3rd bidder.
Yes, my lord.
Then 2 of you.
And in the financial bid.
Let us see financial bid evaluation.
Page number. Minus of the financial bid, my lord. It will be my lord minus page 62, my lord.
62. Technical bit of science. Yes.
62, my lord. Down with the following observations are made, my lord. MS Tier Enterprise has quoted a bid price of 3 crore 27 lakhs 58,958.51 rupees, my lord.
RGM is who?
RGM is the private respondent, my lord.
So they are not. You are not same. You have not quoted same.
RGM has quoted hardly 150 rupees or 100.
Doesn't mean, but it doesn't mean that you have quoted the same.
Yes, we have quoted the same.
You cannot be called L1, both are L1.
No, there is the order of the financial bid, my lord. Now, come to page 63, my lord. The financial bid was opened on 1/5/2025, my lord, at 10 100 hours and was evaluated. One, MS PR Enterprise has quoted a bid price of so and so, only which is less than minus 7.76%. Then the tender cost. Two, MS RGM Enterprise has quoted bid price of 3 so and so, which is less than minus 7.76% than the tender cost. Also, the justified rate of the buying block is approved at the rate of 7.76% below the BOQ amount. White order dated so and so, Itanagar dated 21 April 2025. Hence, the members recommend the following firms for comparative statement as stated below. MS PR Enterprise L1, MS RGM Enterprise L1.
How it's possible? There's a difference in price. Price bid quoted by both the parties.
My lord.
Both the bidders.
Yes, my lord.
It
But
cannot be
this is
same.
the tender evaluation committee, my lord. This is the report, my lord.
No, you can see this 3275895.51.
Yes.
By you.
Yes, my lord.
Respondent is 32758.
253.
253.27. There's a difference we can make out.
600 rupees. Hardly.
Maybe. But then there cannot be, the percentage cannot be same.
But it is their document. This is a document of the respondents, my lord. It's
Yes,
not my document. Then, my lord, I filed a representation, my lord, stating that they should be rejected, my lord. The tender should be rejected. However, nothing was done by the respondent authorities, my lord. Thereafter, my lord, to the surprise, my lord, on 6th June.
So according to you are registered contractor as per the Act and rules.
Yes, my lord.
Enlisted contractor, and you have quoted the same price as that of respondent number 6. You are equally a L1.
My lord.
Therefore, since the respondent number 6,
my lord,
is not enlisted contractor.
Yes, my lord. My lord, my main
and has not submitted the solvency certificate from the nationalized bank.
Yes, my lord.
He should not. Your case should have been considered or preferred than the respondent number 6.
Yes, my lord. I have hardly, my lord. I have got only 3 issues, my lord, here, my lord. Number 1, my lord, since the private respondent is not enlisted contractor, he is not eligible. Number 1, he should not be allowed to participate in the tender project.
Yes.
Number 2, because in the specific condition of tender, he has to submit a solvency certificate from a nationalized bank, which he has not done, my lord. So, number 2, my lord. And number 3, my lord, now he is a contractor who is enlisted under the Assam, my lord. AP, Assam Public Works Department, my lord. My lord, in Assam, the bidding capacity is 1 crore, class 2.
That is not relevant.
But then, since
once you say that the requirement under the Act and rule or the NIT,
my lord,
that the one has to be class 2 and then
enlisted under
the rules or the Act.
Yes, my lord. Huh? Yes, my lord.
Then where you should go, whether Assam there was the amount of bidding capacity.
That is there, my lord.
But then we find that you have not quoted your rate is higher than the respondent number 6.
So what, my lord? But first of
all, they said that it is same percentage. It cannot be same percentage.
Okay, my lord. That I agree, my lord. But however, my lord, since private respondent is not eligible, my lord, how can he be?
Where is the solvency requirement of? Oh yes, I've seen it.
Yes, my lord.
Of nationalized bank.
Yes, my lord.
Where is that solvency certificate of respondent number 6? It's from ICICI.
ICICI Bank, my lord.
So ICICI is now, according to its nationalized bank.
My lord. But then
where it is?
My lord.
The solvency certificate.
My lord.
Where it is?
My lord will find it at page number 103.
103.
And bank certificate 104.
Solvency certificate. requirement is
Next
next
slide.
page 45.
40. Page 45, my lord.
Solvency from any nationalized bank, not less than 50% of the tender amount. That's all.
Now, again, my lord, if my lord comes to page 48 also, my lord.
What is there?
At clause 25, it is specifically written, my lord. The tender shall also be governed by the Arunachal Pradesh district-based entrepreneur and professional initiative and
Page
48, my lord.
Page 48
Clause 24, my lord.
plus 24
Yes, my lord.
of tender special condition.
Yes, my lord. Additional conditions, my lord.
Yes.
Now, my lord, once they are not registered, they are not enlisted, my lord. They are not eligible. That is my submission, my lord. And if they are not eligible, my lord, they were not supposed to. They were not.
Then whatever the other matter.
Same issue, my lord. The amount is different, my lord. The CD block is different.
This is block and amount are different. Grounds are same.
Grounds are same, my lord. This is 3
Not
crores.
enlisted.
Not enlisted.
Same party.
Same party.
Same party.
Same party.
GR or GM enterprise.
Yes, yes, my lord.
GR.
TR and RGM.
RGM.
Same party.
RGM same party.
Same party.
Only amount and that the CD block.
CD block.
Different.
Here.
Advertisement. I mean NIT. Same date.
Same date.
Same date. NIT.
NIT.
By same order. I mean same.
No,
NIT.
no, not same NIT. Different NIT. My lord.
Different NIT, but same date.
Same date.
Okay.
My lord, I'll just have some side. Now, this issue has been already decided by the division bench of this our Honorable High Court, my lord. The eligibility, my lord, whether a contractor which is not enlisted under the 2008 rules, my lord, whether that person will be eligible.
Citation
2020, volume
2020,
volume 5.
volume 5, GLT. Then page
258.
258. Party, name of the party?
Name of the party is, my lord, DDL Enterprise.
DDL.
MS DDL Enterprise versus SEBI Allied Agency. SEBI Allied Agency.
Para?
Para, my lord, the relevant para will start from, my lord, para 20.
22?
20 to 26, my lord.
26.
May I read it, my lord?
It's okay.
But my lord, para 22 makes it very clear, my lord. It specifically says that once
You give the Xerox copy, huh? Xerox.
he should not be allowed to participate. And another small citation, my lord.
No, it's enough. One will be enough.
Yes, my lord. This only that since
Saying what?
it's specifically provided in the NIT, that certain conditions are provided, my lord.
It
Once
has
the
to
state is,
punctiliously observe
yes, it
or
has
adhere to.
yes, my lord. The state cannot back out from that, my lord. Once it is provided. Anyway, my lord, I will just give the citation only.
Yes.
1979.
Yes, why you 79? 2025, where on 2025?
Anyway, my lord.
I'll give you citation
My lord.
on that.
My lord.
2025.
My lord. That's my humble submission, my lord.
Okay. Anyway, I'll record it because tomorrow you may say, yes, citation, just give the citation. 1975,
3 SSC
3 SCC
489.
489. Name, please. Party's name.
Ramanath Dayaram Sethi versus International Airport Authority of India and others.
Sethi. It's 1975.
79.
That's what I'm saying. 79. right?
79.
You said 75.
Oh, sorry, my lord.
You could have said Adi Sethi. Yes.
My lord, the petitioners, they have declined to file any reply. First of all, my lord. Now, at page 211 of our affidavit, my lord.
Okay, just wait. Which para you are this Shetty you are relying? 10, 13. Okay, yes.
211
211.
of our reply. Why the petitioner was not considered, my lord?
Yes.
It's dated 5th June 2025. It is by the Joint Director Ari, who is the accepting authority, my lord.
Yes.
My lord, may I read the second paragraph? As per section 20, para 20.4.3.1, the details of comparative statements, both in physical and financial, have been worked out and annexed A for CD block Talia and Payang of Upper Subansiri district. The ground of rejection.
This is both Thalia and Payang.
Payang.
This
Yes.
is two writ petition in respect
Yes.
of Thalia and Payang.
Yes, madam. The ground of rejection for respective packages who do not quote as per justified rate are specifically mentioned. On the other hand, the firm's vendors who have qualified in the technical bid for the comparison of rate among the bidders for consideration are given in financial comparative statement. As per District-Based Entrepreneurs Act, MSTR Enterprises have already 3 works in hand and close acceptance letter issued by the Executive Engineer PWD RWD Division Daporizam.
Okay.
My lord, the NIT was issued. If my lord kindly see at page 32 of the writ petition. We have also annexed it in our affidavit, my lord.
Respondent 2 and 3.
Yes, my lord.
Yes.
206 at page 206, my lord.
Yes.
This NIT is dated 11th April 2025. In the column at 206.
This is Payang.
Yes.
Second writ petition or first writ petition.
First writ petition.
Payang is first writ petition.
My lord.
Second is Thalia. Okay. Yes.
My lord will kindly see period of the document at serial number 9, column 9, deadline for receiving bids online, including scanned copy of demand draft, dated is 29th April 2025. Time is up to 1600 hours. My lord will kindly see. I'll just read again. Deadline for receiving bids online, including scanned copy of demand draft towards cost of bid documents from scheduled commercial bank and scanned copy of affidavit. My lord, this was on the last date was 29th April. He has in our annexure 4 series starting from page 213.
Yes.
Sorry, my lord. That work orders, my lord, has been.
No, why you are referring to this clause 9? Serial number 9?
Page number 206, my lord. 206, the deadline was 29th April 2025.
Yes, then?
Yes. Prior to that, he had already 3 works in hand.
So what is the requirement of not that you should not have the 3 works?
Yes, ma'am. I'll be coming to that, madam.
Come to that.
Yeah, 3 works in hand. It starts from page 208 onwards, my lord. 22nd March. One is 22nd March, my lord. That is 2025. The at 209 is on 28th of March. This is letter of acceptance. And 210. That is also 28th of March. All prior to the last date of submission of the bid documents, my lord. Now, my lord, 48 of the writ petition, my lord. This is a part
Requirements
of,
three works and at hand.
yes, my lord.
Page 48.
48.
Yes.
Page 48, last column 26, my lord. The tender shall submit an affidavit for not more than 2 works in hand duly signed by the judicial magistrate. This was a condition, madam.
26. He has not filed that.
He has not filed. He has rather suppressed. He has filed, but rather suppressed that he had 3 works in hand, madam. And this page order at
But your rejection is not on that basis.
madam, our rejection is on the order of at page 211.
Pertaining to supply and procurement. Page
211 is the
211. Okay.
this is not under challenge by the
No, it's not based on having three works at hand.
no, it is based.
It is.
Yes, madam. 211. Why petitioners?
Oh, already 3 works in hand.
Yes, madam.
Okay. Now,
okay,
he may not be.
He has
but
not
at the
challenged
same time, the respondent 6 is also not eligible.
he has not challenged this, my lord.
Anyway,
Yes,
respondent
ma'am.
6 also doesn't.
Now I'll explain, my lord. He has not challenged this, my lord. This rejection is not under challenge, my lord. Now, the NIT at page 32, which my lord has said, NIT is the invitation is for registered contractors from APPWD, CPWD, BRO, GRIF, APWD. APWD is also Assam Public Works Department.
Where it is?
At page 32.
NIT.
Page 32 of the writ petition.
APPW, CPW, BRO, GRIF, APWD.
On appropriate categories of class 2, domicile within the jurisdiction of assembly constituency. My lord, here, this NIT is not under challenge, my lord.
Shall be governed by Arunachal Pradesh.
My lord,
Act.
yes, my lord. That is something, my lord. But this NIT itself has invited eligible contractors registered under CPWD, BRO, GRIF, APWD.
Sir, you cannot read up to the domicile within jurisdiction assembly.
Yes, my lord.
Shall be governed by.
Shall be governed. Shall be governed.
Governed by Arunachal Pradesh.
Yes, my lord. I'm coming to that.
Entrepreneur.
Shall be governed.
And it is to be read along with all the conditions of the tender.
Shall be governed. My lord. Here, what is required? These are the eligible contractors they should be domiciled, and the tender process shall be governed by the District-Based Entrepreneurship Act. Now, this invitation makes it clear that even APWD contractors, registered contractors who are domiciled in the district, domiciled in the jurisdiction of the assembly constituency.
In the category of class 2.
Class 2 is eligible.
Eligible.
My lord.
And same shall be governed by Arunachal Pradesh.
Yes, same shall be governed. The same shall be governed. But
so Entrepreneurship Act, what is page?
Page, my lord, 60. 69, my lord, 65, 68 onwards, my lord.
68. The Act says, my lord, a contractor has to be, even if he is from a different, if he is registered under different works department, my lord, he has to be enlisted under the Arunachal Pradesh Contractor Enlistment Rule. It provides, like it's in the act itself.
My lord,
Close to,
Yes.
subclause to, subclause A.
Clause 4.
Yes, ma'am. The contractors, entrepreneurs, before participating in the tender must satisfy the following conditions, madam. If there are contractors, my lord, who are from the state, if they have not registered, they have to register. Yes, they have to enlist under the. Now, my lord, here the NIT has been called already, inviting it from other authorities, my lord, other states. In the NIT itself. You cannot ask someone, a BRO registered one, to get it yourself registered in the APPWD as part of.
But your tender itself said it should be governed by this act. This act provides that the contractors, entrepreneurs.
Yes, my lord, but the tender
before participating in the.
Yes, my lord, the
Tenders must satisfy the condition, district-based entrepreneur and professionals.
Tender itself has said that these are eligible contractors. This BRO, APWD, all this. Tender has also invited them.
No, the invited, provided that these conductors must be, bidders must be, any conductors must be, shall be guided by this act, entrepreneurship act.
That is for a different, not to be registered, my lord.
No, you cannot.
Not to be registered, my lord. It will be guided because of there are certain criteria for domicile, the bid capacity. It will be for those purpose, my lord. Otherwise, the invitation from APPWD, my lord, first, this is registered contractors from APPWD, meaning thereby those already registered. Then CPWD, it covers already registered one, then CPWD, then BRO, CRIF, APWD also. What is the requirement here is of appropriate class and the domicile within the jurisdiction.
Which shall be governed by the act.
My lord, domicile and my lord, that's why here we have to also totally not nullify what is the invitation for. We cannot totally nullify everything because once then NIT is not under challenge.
No, NIT is not saying, he's relying on the NIT itself. He said one may be a registered contractor of other state or other organization, but it must be to participate in the tender. As per the NIT, one has to be enlisted in these rules 2008. That is what he's saying. Because the NIT says so this shall be guided by this act 32. So you cannot say that. I mean, which is not, you just cannot apply. It has to apply uniform.
My lord, here, my lord,
Dismissal within the Jurisdictional Assembly consists shall be governed by, not guided, governed by the Arunachal Pradesh so-and-so Act 2020. So you'll have to read with your act of entrepreneurship, entrepreneur act.
We'll come back.
We'll continue it.
Yes. my lord, I'll shorten my arguments, my lord.
Yes.
The first contention that the private respondent is a contractor registered under the Assam PWD. That will come later. The second contention is that the earnest money, the security deposit, was not by a nationalized bank, rather by a commercial bank. In this regard, my lord, in the NIT itself, which I read, my lord, at clause 9, where the deadline was given. It says the deadline for receiving bids online, including scanned copy of demand drafts of bid security and demand draft towards cost of bid documents from scheduled commercial bank and scanned copy of. That is at page 32 and 33. So NIT itself provided that the bid security and the demand draft for bid documents will be scheduled commercial bank. And this aspect we have given in our affidavit also, that there are other clauses in the NIT itself, which I have not annexed, but I have the entire NIT. If my lord, can we see it? Page. At page 32, it is the part of the NIT, my lord. My lord has seen in the column below, my lord. Page number is given below, my lord. Clause 11. Clause 11, my lord. The contractor whose tender is accepted will be required to furnish performance guarantee at a specific percentage of the tender amount as mentioned in Schedule E and within the period specified in Schedule F. The guarantee shall be in the form insurance security bond, account pay, demand draft, fixed deposit, or bank guarantee of any commercial bank. It talks about commercial bank, my lord. The contractor whose tender is accepted will also be required to furnish by way of security deposit for the fulfillment of his contract an equal amount of so and so, so and so.
This is bank guarantee. It's
Bank
talking
guarantee.
about solvency certificate.
Yes, my lord. Here in the NIT, my lord, NIT demand draft of bid security in the at page 32 itself, bid security. It's solvency certificate, bid security, solvency certificate.
Why you have made some separate provision here?
That was given in the NIT, my lord. Of course, my lord, I'm coming to that, my lord. It is something I have also noticed. There is some inconsistency in the tender, NIT and the tender bids, tender documents, my lord. At page 32, my lord, we'll see.
The solvency certificate is, submitted before the tender is
Yes,
accepted. This clause 11 is talks about tender is accepted.
Accepted. So it also talks about commercial bank, my lord,
This
and the
is
bid
demand
security.
draft, fixed deposit, bank guarantee.
Yes. The
solvency certificate has to be submitted before the
Yes, my lord.
acceptance of the tender.
That is in the NIT itself, my lord.
Yes, this
yes,
is what he's saying.
NIT itself, page 32.
It should be nationalized bank.
My lord, here in NIT, at page 32, it says the security, bid security, meaning thereby the solvency certificate. it talks about the commercial. Of course, there are some inconsistencies I've also noticed in the NIT and the tender documents, my lord. Now, this second aspect, my lord, regarding.
Where is the requirement page?
3, my lord, the list of documents, my lord.
50?
3. And my lord, may also come to page 45. It's given in page 45.
The tenderer must produce the following documents, furnish the original copy of documents while submitting the tender papers and during opening of the tender. This clause 11 in respect after the acceptance of the tender, bid security.
Yes, ma'am.
And this requirement list of documents to be furnished is at the time of while submitting tender papers and during opening of tender.
Yes, ma'am.
There is solvency certificate from any nationalized bank not less than 50% tender amount. And this is bid security, is something different. This is after the acceptance.
No, my
The
lord,
tender.
bid security, copy of and bid security and demand draft. Bid security. It talks about bid security, my lord.
No, these are the clause 13, page 45 is required at the time of opening,
Yes, my lord.
at the time of submission
That's
and
why, yes, my lord. That's
opening.
why I'm
And
submitting that.
clause to 11 is for submission of bid security and other
Yes, my lord.
bank guarantee.
After the acceptance of the tender.
Clause 11 is after acceptance of the tender. my lord.
What he's saying is he has submitted, the respondent 6 has submitted this solvency certificate from ICICI, which is not a nationalized bank. That is what he's saying.
My lord, what we call, what he's terming, it's a solvency certificate. We call it a bid security, which has been given by the ICICI Bank, my lord. And as per the NIT, we are required to furnish the bid security from a commercial bank.
After the acceptance of
No,
the tender.
no, my lord, at the time of,
No, where does it say?
my lord, at page 32
Of what?
of the writ petition, that is the NIT, my lord.
Page 32.
Yes, my lord. Column 9, my lord. Deadline for receiving bids online, including scanned copy of demand draft of bid security and demand draft towards cost of bid documents from scheduled commercial bank and scanned copy of affidavit.
No, this is something different.
This is required at the time of submission of, while participating in the tender, we will have to submit this. Therefore, my lord, I am submitting that there are inconsistencies in the NIT as well as the tender document.
No, this clause 9 is inconsistent with, it is consistent with the clause 11 of the tender document. And this page 45 is something different.
Yes, my lord. This page 45.
The special condition.
Yeah.
Where the tenderer has to produce the following documents, furnish the original copy of documents while submitting tender papers and during opening of the tender.
Yes, my lord. Original copies online also is, that's why it said scan copy of demand draft, which has been which has to be submitted along with the tender paper.
So according to the solvency certificate can be from a commercial bank.
Yes, my lord.
Then what about this clause 13, page 45? It
Therefore, my
clearly
lord.
says solvency certificate
Yes,
of
my
any
lord.
nationalized bank.
Nationalized. My lord. Here, therefore, I'm saying that there is inconsistencies between the in the NIT as well as the tender documents. My lord.
So we'll resolve it.
My lord, that's why the authority has accepted
No, no, this is a special condition of contract.
Authority has
I mean,
accepted,
tender.
although there are, these are inconsistencies, the authority has accepted. It makes no difference, my lord. Oh, in one, we are saying, that commercial bank, it can be accepted from commercial.
No,
bank.
clause 9 in the NIT provides a different kind of this thing. This is bank draft and all other bid
Yes,
security.
with security. With security. Bank certificate, what they have annexed at page 104 is the bank certificate. Solvency certificate is at 103, my lord. Based on this,
So if there is an inconsistency, which one will prevail?
my lord, there is an inconsistency.
So which one will
So,
prevail?
my lord, my humble submission will my lord, the private respondent's bid is 105 rupees less than the petitioner, my lord. 705 rupees less than the petitioner. My lord. The petitioner has been found that he has already 3 works in hand. And that is the reason for rejecting his bid, my lord. Now, there is a legal point raised that the NIT.
When the price quoted are similar, same price quoted,
No, my
how
lord.
you say that it is both are L1?
Exactly. That has been, therefore, in our affidavit, the amount has been mentioned. The amount has been mentioned. In fact, it cannot be, both cannot, when there is a difference between the amount quoted, it could not have been said that both are L1. Even 1 rupee difference, the L1, it should be L1 and L2. But what the district board they have done is declared both L1. But the accepting authority is the joint director RE, who is the accepting authority. He has passed, he has calculated and said that there is a difference. The price quoted, rate quoted by the private respondent is less than the petitioner, madam. It is on the face of record itself, the amount has been mentioned. Now, this amount is not disputed, and it cannot be disputed that the private respondent has quoted lesser than the petitioner, madam.
What is the decision? Evaluation?
Evaluation, my lord, will find, my lord. That evaluation, my lord,
The page, the financial. My notes of the financial, page 62 of my affidavit.
62,
62 and 63.
63. This is by the,
No, it's less than, what is this?
it's a percentage they have fixed, below which the firms are not allowed to quote. But the figure remains that the private respondent has quoted 705 rupees less than the petitioner.
You are which?
This is by the
387, red petition.
386.
386. So, who has this? Yes.
At page 63. And even at page 62 also. The price quoted has been clearly mentioned, madam.
Which is less by 7 minus 7.6.
Yes, yes. This the district
and which
board.
is also by same
District board they have,
But district board is so poor in mathematics or what?
a final accepting authority is the joint director RE, my lord.
Yes, as you say, there's a difference in price way.
Yes, my lord.
Price quoted by the parties. When you are saying that it's the same, less than by minus 7.76%,
Yes.
and L1. Very clear. It appears to be very clear.
Yes. Now, my lord, the price, my lord has seen from the price quoted by both the petitioner and the private respondent. Private respondent has quoted this. And it is admitted that there are inconsistencies in the bid documents and the NIT, my lord.
There's no inconsistency.
My lord, and then
In special condition, the bidders has to submit solvency certificate from the nationalized bank so far as the bid security after the acceptance as per clause 11 can be from the commercial bank, any demand draft and all those things. And in the NIT also clause serial number 9, it talks about bid security and other things. It doesn't talk about solvency certificate.
my lord, these are,
Solvency certificate is akin to bid security.
yes, my lord. These are aspects which the department has gone through. It doesn't make any much of difference, my lord. What is required, my lord, therefore, my lord, is that these are technical things, whether it's from a commercial bank or a nationalized bank. And therefore, I'm saying that, my lord, in the NIT, in the NIT, it talks about commercial bank. In some clauses of the bid document, it talks about nationalized bank as well as commercial bank, my lord. These are inconsistencies. Now, these are and the vital issue raised is with regard to the district-based entrepreneurs. The NIT invited contractors apart from APPWD, other BRO, brief and all, including APWD, Assam Public Works Department, saying that it should be in category 2 and domicile of the jurisdiction, madam, assembly constituency. Now here, the NIT says this, invited all these other contractors, saying it should be a domicile and in category 2. But the rules itself says that to participate in the tender, you have to be enlisted under the enlistment rules of 2008. These two, of course, these are inconsistent. On one hand, you are inviting other contractors, but your rule says that to participate in the tender, you have to be enlisted under the enlistment rules. Here, if the condition that it should be enlisted under the enlistment rules 2008, if it becomes mandatory, then it will be fruitless and it will be useless to invite other contractors from BRO.
Who has done it?
Yes, my lord.
Not by the bidders.
Yes, my lord. Not by the bidders. No, my lord.
So go for press tender.
Of course, there is a legal point here. But what is the main requirement under the Act itself is for equitable distribution of works, my lord, in the nook and corner of the state, my lord.
Therefore, three works at hand.
3 works at hand now.
Comes into play.
Yes, my lord. Now, these are legal issues that has been raised. Of course, it's a legal issue, my lord. It's a very interesting legal issue, whether the NIT will prevail or the conditions of the tender documents will prevail. These are legal issues, which is rightly pointed out that it is a legal issue really to be determined, my lord. Now, however, my lord, in tender process, what has to be seen by this honorable court is that in the public interest, what public interest will suffice, my lord? What will be in the furtherance of public interest, my lord? That only, my lord. Because, of course, I say that there are inconsistencies in the NIT as well as the tender document. And it's a legal issue, vital, very interesting legal issue raised. Now, rightly, wrongly, the department has given the LOI to the private respondent because his rate has, he has quoted lesser than the petitioner, although negligible for an amount of 705. Now, on that aspect only, my lord, I'll submit, my lord. The citation relied by my learned friend. In fact, it is the judgment of the Honorable Division Bench. In the learned single judge, bench, I appeared, my lord, for the petitioner in that case. In that case, my lord, the NIT itself was invited only for APPWD. In the NIT, there was no other.
What is this?
The judgment of the learned single bench.
Single bench why?
No, my lord, here, because
this was upheld.
Yes, this was upheld by the division bench, which my learned friend has relied, my lord. The construction, my lord, DDL enterprise. Here, my lord, in the learned single bench, my lord, the NIT itself, my lord, will kindly see the
difference is the only
difference is that in that NIT,
only from the PWD, Arunachal PWD.
It was
not
invited.
From other district.
Yes.
So you are trying to distinguish.
Yes, my lord. Because in that case,
Yes.
only the PWD, Arunachal Pradesh PWD contractors were invited, man. Not the BRO or BIF or any other APWD were invited, man. So there is a slight of difference, my lord. Now here,
yes,
as I have said, there is an inconsistency between the NIT and the tender documents. The NIT itself, I would say, I would humbly say that it is not in consonance with the Act of 2015, my lord. Anyhow, my lord, the NIT has been floated. Petitioner has participated. The technical bit of the private respondent was found responsive along with the petitioner. Petitioner never questioned his ineligibility. When the technical, there are two bit system, my lord. First the technical bit. When the technical bit was, when the private respondent was found eligible, responsive in the technical bit, petitioner did not challenge it. It is only after he was not awarded, then he comes up with this challenge. At the time when the private respondent was found technically responsive, petitioner did not object to that. It is only after his financial bid was not accepted, it is for 100 days works. In a,
where is the requirements of three? What is that?
in the rules itself.
The rules,
Rules
Rules only.
yes, in the act. my lord. And wherever
There is no condition in the, this is not the terms of the tender.
no,
It's a,
it's an act. Now, wherever there is a discrepancy in the act, it goes, the government goes in favor of the private respondent. And wherever there is, where they cannot do anything, it goes against.
it's,
And it is from the same rule, man. They don't apply, subclause 4.
So they are selectively applying the rule.
Exactly, my lord, exactly, my lord. When solvency comes there in their favor, when there are 3 tenders in hand, they are in their favor.
See,
But when the moot question
it's
comes,
okay. There's no inconsistency according to this court with regard to insolvency certificate and the bid security.
these are,
Because bid security is something different, which you have to furnish. I mean, what do you call it? What is solvency certificate? Solvency certificate is something like it's a financial health. Therefore, you are required to furnish at the time of submission and opening.
yes, madam.
Bid security is to be submitted maybe at the time of submission also, but then this is something, a guarantee.
Yes, yes.
That in case you are given or after your tender is accepted, you will have this guarantee,
Yes,
financial guarantee, security.
security.
There is
Now-
no inconsistency because clause 10 and clause 9 of NIT and the state, I mean, conditions, special condition of contract, I mean, tender is with respect to the bid security, demand draft from any commercial bank. But as per clause, that is 13.
yeah, my lord.
Solvency certificate 13.
My lord.
Clause 13, it is a solvency certificate which has to be produced or furnished at the time of opening,
Right.
submission and opening with the original from a nationalized bank, which
Yes,
the
right.
respondent number 6 has not submitted.
Right.
So far as the solvency certificate is concerned.
Yes, my lord, rightly said.
So there is no
Now, this
inconsistency.
looking into, yes, my lord.
So you are admitting that the solvency certificate is not from nationalized bank.
Yes, it is not, it is from ICICI Bank,
Okay.
my lord. But in any case, we have,
ICICI is not
yeah,
a
we have,
nationalized bank.
we have written to the ICICI Bank and we have accepted.
Nationalized bank is only State Bank of India.
No, my lord. There are,
Huh? Okay, okay.
we have written to the ICICI Bank confirming this and we have accepted that it is in our affidavit, my lord.
But your requirement is to from
My
the
lord, the-
national,
my-
I mean,
the,
nationalized bank.
Yes, my lord, the accepting authority has accepted, saying that, okay,
So you may say
because-
that this is not an essential
yes,
condition
my
of
lord,
the
this is
contract.
not an essential, not a strictly essential condition of the,
Poddar is still,
yes.
or is
So,
still Poddar.
yes, so long as it is valid, my lord. So now, therefore, my lord, one thing is that he has not challenged.
So he has got it, according to you, actually,
He has
is
quoted
L2.
L2.
Okay.
He has quoted, the private respondent has quoted less than the petitioner.
So
He has
according
three
to you,
works.
so far as the registration, I mean, enlistment is concerned, as per the rules, it is the only the contractors
Who are
register under the
enlisted under
Arunachal
the
Pradesh PWD, they have
Yes.
to register, enlist
enlisted.
under the rules,
Under-
not the contractor registered from other states or the
Yes.
other, I mean, organization.
Yes, my lord. As per the rules, it says that the contractor who participates in the tender should be enlisted under the 2008 rules. As per
Because
the NIT,
it pertains to those contractors who are registered contractors under Arunachal PWD.
yes, my lord.
Those registered outside the state, I mean, PWD registered because they are
There is
separate.
an inconsistency, what I said. My lord,
No, no,
my,
according to you.
my lord, my submission is not that. What is that? There is an inconsistency in the NIT and the bid documents, the rules also. The rules specifically says that to participate in a tender, one has to be
enlisted
enlisted
under the
rule.
2008 rules.
Yes, but-
Therefore, if you invite the bidders or contractors registered other than the PWD, you should have clarified.
Yes, my lord. My lord, that's why, my lord, the rule says otherwise, and the NIT, but the NIT has opened it and invited contractors from other organizations, my lord, also, apart from the PPWD. Now, there is an inconsistency between the NIT, and the rules also. Therefore, my lord, it's a legal question which has been raised.
You will decide.
Legal question raised, my lord. Now, therefore, my lord, what I'm saying, after all, ultimately is the public interest in tender Manrega for supply of materials under Manrega, which is 100 days work period for the entire year, my lord. We are in the month of October, my lord. Hardly 4 months remain. And we have to, otherwise, it is not only the contractors, it is the these beneficiaries under Manrega who will be the ultimate sufferers. In the event
4 months.
Yes, ma'am.
We'll decide this week.
And
by today,
and my lord,
you go
therefore,
for
my lord,
president there, of course, subject to.
my lord, my one last the Tata
Madam, subject.
Tata Motors case, my lord. I would just say rely on that page para 53. I'm just handing over.
Just give that citation.
This is from Supreme. Today I have downloaded, my lord. In the SEC, it will be a different, my lord, the paragraph. I'll just rely on paragraph.
Tata Motors.
Para 53 in as per this Supreme today. It will be different. 53. I'll just read one paragraph, my lord. My lord, para 53, the last page, my lord. Last page of para 53. Para 53. The law relating to award of contract by the state and public sector corporations was reviewed in Air India Limited versus Cochin International so-and-so. And it was held that the award of contract, whether by a private or by the state, is essentially a commercial transaction. It can choose its own method to arrive at a decision, and it is free to grant any relaxation for bona fide reasons, if the tender conditions permit such a relaxation. It was further held that the state, its corporations, instrumentalities, and agencies have the public duty to be fair to all concerned. Even when some defect is found in the decision-making process, the court must exercise its discretionary powers under Article 226 with great caution and should exercise it only in furtherance of public interest and not merely on the making out of legal point, my lord. It's a legal point they have made out, my lord. That's all, my lord.
My pleasure, Lordship.
Yes.
Lordship seems to have traveled more than halfway into the decision making, but still I'll
No,
try to give my best.
I'm just suggesting him.
Yes.
I'm not yet between.
Lordship, let us come back again to page 69. This is 69 of the writ petition.
Writ petition.
This is the rules. The Arunachal Pradesh District-Based Entrepreneurship and Professionals Rules 2015. Part of the rules which was read out. Rule 4, clause 4, subclause 2, subclause A was read out to say that he must be registered under the enlistment rules, contractor the contractor oblique entrepreneurs before participating in the tender must satisfy the following conditions.
Yes.
One of the conditions was, as pointed out, that they have to be registered under enlistment rules of 2008. Another condition is E. This is the requirement of not more than 2 works. This has not been read out, therefore I'm just pointing it out. In the larger interest of the public for equitable distribution of development works among eligible contractors and also to ensure effective management and quality of works, a contractor shall be allowed to have only 2 works at hand of any department under the government of Arunachal Pradesh at a time, and for which he shall make a declaration. This is at page 69 of the writ petition. This is a part of the rules of clause 4, subclause 2, E. E.
Okay, in the larger.
Yes, in the larger. This is not very clear.
Yes.
For which he shall make a declaration to be executed in affidavit that he is not engaged in not more than two any tender works under the state government. He shall also, for participation in any tender, be required to submit completion certificate issued and the engineer in charge duly countersigned by the concerned superintending authority, engineer and chief engineer. This is also one of the requirements for eligibility, which he has not fulfilled as shown.
In technical evaluation, technical stage, he could have been
He filed an affidavit.
rejected.
He filed an affidavit saying that he does not have more than 2 works. He had misrepresented before the authority. It was found out later on that is how his bid came to be rejected in the scrutiny by the accepting authority. Now there are 2 stages, Lordship. In the department, there are two stages. One is by the district authorities, district board, which had recommended both of us as L1. Lordship has seen that. Now the petitioner has told only half the story. Under the rules, after the district board sends its recommendation, the accepting authority can, before accepting, see the papers if it is in order. If it is not in order, then do the scrutiny again. That is how I was declared as L1 and he as L2. This discrepancy was detected by them. I have annexed this also in my affidavit. This is how I was awarded the LOI.
Otherwise also you are L1.
Yes, others also. This mistake was detected, Lordship. This is in terms of their, Lordship, page 155, may I see? Page 155. And just the procedure I'm going to show.
Of the affidavit?
No, of my affidavit.
Yes.
Respondent 6. Under the special conditions, Respondent 6.
386.
386. Page 153 onwards, but the operative portion is at page 155. Has my lordship found page 155?
Yes.
Awarding of tender, clause 14. Awarding of work order, sorry. Clause 14, subclause 2, the joint director RE, from the beginning I'm going to read. The tender shall be evaluated by the boards constituted by the DC, come DPC on district level and recommended at least 3 forms, L1, L2, L3, to the competent authority for acceptance along with relevant documents. Now, after the district board evaluates the tender, it is sent to the department joint director RA. In subclause 2, the joint director RE shall further scrutiny the tender documents recommended by the project director. LOI will be issued to L1 firm if the tender documents recommended by the project director is up to the satisfaction of the acceptance authority. The project director will issue supply order to L1 firms on the basis of LOI issued by the acceptance authority. So the accepting authority has found that the recommendation made by the district board was wrong So therefore, your lordship has seen only till the minutes of evaluation of technical bid. Further, what happened, lordship? Further, what happened is that this was sent to the Office of the Director, Rural Development Department. I have annexed at page 127. Lordship has seen and heard only till page 126. Page 126 is the evaluation report of the financial bid, in which both of us were declared as L1. Thereafter, what happened? On 2nd May, it was sent to the Director, Rural Development Department. This is at page 127.
127.
127 of my affidavit. The in the petitioner's writ petition, all these things have not been mentioned, Lordship. Therefore, the confusion, even the department has not specifically shown these documents, that is why. Page 127. This is the, through this letter, this recommendation was sent to the director. Then page 128 is the item-wise evaluation. Then Lordship may see page 129. This is the result, lowest amount quoted by RGM Enterprise. This is respondent number 6. Then Lordship.
This is sent by the
accepting
authority.
This is done by the accepting authority. Then Lordship, after it is sent, the accepting authority scrutinizes it and sees whether it is in order. It was found it was not in order. So therefore, re-scrutiny was done by page 131. Lordship may see page 131. The amount is exactly the same as sent by the district authority, district board. But the conclusion that they drew from those amounts has been mentioned in page 131. This is the scrutiny made by the accepting authority. Lordship may see below. RGM Enterprise as L1, MSTR Enterprise as L2, hence recommended for approval from competent authority. Page 131, Lordship has seen. So that is how the LOI was issued to me. And furthermore, my learned friend has already shown that there were, it was also found that he was already engaged in more than 3 works at that time. So that is why, there was also one of the reasons why his tender was rejected. Now, Lordship, the question is,
yes,
it seems if we are playing a game, it would be 1-1, because he is saying there is a violation of the District Entrepreneurship Act. So therefore my firm ought not to have been given the work. I am saying he has also violated the District Entrepreneurship Act.
So both go.
Also, Lordship, but there is a difference, Lordship. There is a difference in the sense that he is the one seeking positive direction from this court. So therefore, the burden is heavier on him. Number 1. Number 2, he has also not come to this court with clean hands. He has not been upfront about the reason for his rejection. It cannot be said that he doesn't know that there is a re-scrutiny because it is in the additional terms of the tender itself. It cannot be said that he did not know that he made a wrong affidavit. In fact, the wrong affidavit, on the face of it, he ought to be prosecuted under the law. But we are being very mild on this. We're not making any such submissions. What I'm saying is he a person to be given the benefit of, my lord, this court, my lord, in view of such conduct, Lordship? I have also enclosed the affidavit filed by him. In my humble submission.
Saying that he doesn't have any work.
Yes, he has filed an affidavit. This was only discovered later on. And even before the writ court, he has not said anything to this effect, that there was a mistake, that it was not filed by me. even after I brought this on record by affidavit in opposition, no reply has been filed. Does he, before this honorable court?
Where's that affidavit?
That affidavit, Lordship, at page 167. Of my affidavit.
Engaged is not more than 2 tender works of that is still.
This is a part of the affidavit, that part of the tender document which was taken out. Now, Lordship, my submission regarding the other part, that is the legal point that he has raised. First of all, Lordship, he has not, that even during the technical evaluation, he has not challenged that part of. The NIT, of course, it is full of inconsistencies in the sense that everything has been mixed, and there seems to be a violation of the act itself, the rules, Lordship. But Lordship, the department is the author of the NIT. It cannot be said that they did not know the rules, but still they choose to do it, Lordship. They choose to do it. Now, can this honorable court say, no, this is how you should have done it, this is how it is to be done, Lordship, unless there is a prejudice to any person, or unless there is a...
Why not, if it is, they have acted against the rule, acted the rules, can say so.
Lordship, they have consciously, Lordship, they have consciously invited tenders from other the other works department also, Lordship.
Act and rules.
Lordship, suppose there is a violation of the act and rules also. How does it prejudice the petitioner, Lordship? How does it affect the public interest, Lordship? Because, Lordship, what I'm saying is that NIT in a tender process is the Bible of how it is to be done. They have decided. Of course, I cannot speak for them,
No,
Lordship.
if you are not, if they are not adhering to the act and rules, why the act and rules are being passed and enacted?
Lordship, that is of course for them to answer. But what I'm saying is, the act itself, the Entrepreneurship Act itself, it does not give anybody a right to be awarded a tender. It only says that a preference should be given. A preference should be given. Now, that it is not the same thing as saying that in spite of everything, I should be given the tender works. Now, Lordship, I'm also relying on something else, Lordship.
Yes.
The citations, Lordship.
Yes. Yes.
First is this, Lordship, 2016, volume 8.
Yes. Volume 8.
6 double, I'm giving the copy.
6.
22.
22.
Para 47 and 47 to 49.
Okay.
The result of this discussion is that the issue of acceptance or rejection of a bid or a bidder should be looked not only from the point of view of the unsuccessful party, but also from the point of view of the employer, as held in Ramana Dayaram Sethi in terms of the...
Okay, madam, I've read it.
Yes.
I have quoted
Yes.
in one case yesterday, on Friday also.
Lordship.
Federal culprit.
Now, Lordship, since there are unhappy mixtures, so to say, of two things in the NIT, can, Lordship, can he say that you take this part and don't take that part? Can anybody say, since they have done it, they are the persons to say it, it would amount to rewriting the tender itself. And the tender, and it may not be forgotten that the terms of the NIT it has never been challenged till date. If the If one part goes, then other part also should go.
Relying on the terms of the tender, that you have violated.
But
the
other terms of the tender is against him. He can he say silent on that, Lordship? That is one thing. Another thing.
Both go. Same goes for her as well, my lord.
Now, Lordship.
Same goes for her, my lord.
Now, Lordship, I'm also relying on another one, Lordship.
Yes.
Just on a short point, Lordship.
Yes. What is that?
This is 2021, 16-808. If your Lordship has already seen, then I'm not going to read out again.
Electricity transport.
Yes.
Yes. Para?
Para 14, 16, and 18.
(14, 16, and 18).
Yes. In a series of judgments, this court has held that the authority that authors the tender document is the best person to understand and appreciate its requirements, and thus its interpretation should not be second-guessed by a court in judicial review proceedings. In Afcon's Infrastructure Limited versus Nagpur Metro Rail Corporation, this court has held, we may add that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate its requirements and interpret its documents. The constitutional courts must defer to this understanding and appreciation of the tender documents unless there is a malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. It is possible that the owner or employer of a project may give an interpretation to the tender documents that is not acceptable to the constitutional courts, and that by itself is not a reason for interfering with the interpretation given. Then paragraph 16, Lordship. Further, in recent judgment in Silby Constructions Contractors versus Union of India, this court held as follows: the essence of law laid down in the judgments referred to above is in the interest of restraint and caution that the need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The court should give way to the opinion of experts unless the decision is totally arbitrary, unreasonable. The court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of its requirements, and therefore the court's interference should be minimal. The authority which floats the contract or tender has authored the documents is the best judge to see to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The courts will only interfere to prevent arbitrariness, irrationality, bias, malefice, or perversity. With this approach in mind, we shall deal with the present case. Then, Lordship, paragraph 18. Insofar as conditions 27 of the NIT prescribing work experience of at least 5 years of not less than value of ₹2 crores is suffice to say that the expert body being the tender opening committee consisting of 4 members clearly found this eligibility has been satisfied by the appellant before us without therefore going to the assessment of the documents that have been supplied to this court. It is well settled that unless arbitrariness or malafide on the part of the tendering authorities allege, the expert evaluation of a particular tender, particularly when it comes to technical evaluation, is not to be second-guessed by a read court. In Jagdish Mandal versus State of Odisha, this court noted judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether the choice or decision is made lawfully and not to check whether the choice or decision is sound. When the power of judicial review is invoked in matters relating to tenders or award of contracts, certain special features should be borne in mind. In a contract is a commercial transaction. Your Lordship must know this very well. So
not very well. We have gone through.
Lordship. So the dishonorable court should actually throw the writ petition at the threshold itself in view of his hiding things before dishonorable, not only before dishonorable court, but before the authorities, which was found out and which was the reason for his rejection, Lordship. Before coming to other aspects, this aspect, Lordship, should be seen first, Lordship. This Honorable Court should not entertain the writ petitioner in such a manner, Lordship. Now, although your Lordship may not accept this, but
when we suppose, if we find that the award has been, the contract has been awarded to the bidder, or the contractor, who is not eligible.
Yes.
In terms of the NIT and the condition of the tender.
No, in terms of the NIT, I'm eligible, Lordship. In terms of the NIT, I'm eligible. I am the domicile of the district. I have the, I am a class 2 contractor as required by the NIT. Also, I am a registered contract under the Assam PWD. Now, NIT asks for Arunachal Pradesh PWD, BRO, GRIF, and Assam PWD.
Which shall be governed by the Arunachal.
Yes, which shall be governed.
Which requires that
yes.
One has to be enlisted under
Lordship,
the rules.
interpreting this in this way would amount to nullifying or rewriting the NIT itself, Lordship. It is the authority who has tried to harmonize the thing and who has tried to inspire.
According to you, authority has the intention or the clear as per the NIT.
Yes.
If although it is not given in clear terms.
Yes.
It is the authority. It is the contractor who has been registered under the PWD, Arunachal PWD, that requires the enlistment.
Yes.
Therefore, the other contractors.
Yes.
Who is who is registered other than the Arunachal Pradesh PWD.
Yes.
Need not be registered because they are registered.
They cannot be registered. In fact, Lordship, I have not brought the enlistment rules, but I have seen it.
You are a registered contractor under the PWD. You cannot be registered under the.
Yes, I cannot be.
It is the rules under the Department of PWD.
No. In the enlistment in the enlistment rules, 2008 rules, although I have not brought it, but I have seen it. A contractor can be enlisted under the 2008 enlistment rules only if that contractor is a contractor in a PPWD.
That is very crucial.
Yes, there is their Lordship. Now what I'm saying is, the authorities here, there is a department, it cannot be said that they are blind to this. It cannot be said that they did not know this. But despite everything, they have consciously called for NIT from bidders other than the APPWD, which as per the rules, they are the only ones who can be enlisted under the enlistment rules. Despite that they have called this. Now, how is it prejudicing him? Lordship. That is what I'm saying. I'm also, Lordship may not agree with me, but there is something I would like also to place. I am saying generalia specialibus non-derogant. The District-Based Entrepreneurship Act is the general law in terms of, in fact, I would say it is a niche law, only to give preference to the local contractors. It is not the law. The law in a contract is the NIT. Like I said before, NIT is the Bible. And in the NIT, there can be things which the authority in the inviting tender inviting authority can pick and choose, can tailor make the NIT to suit the work that is intended to be made. They cannot be pigeonholed into saying that you have to follow this. They are the best authority to judge it. So I'm saying the maxim of generalia specialibus non-derogant should be applied in this case.
It is too perfect.
I was aware your Lordship would say that, but
anyway.
Yes.
That's my view. I mean, my understanding. Anyway, let us not go into that much.
Yes,
it's
Lordship.
A tender matter.
If your Lordship is to decide whether or not this should apply, should not apply, these have to be decided in such a manner, in my humble submission.
You have, it's not that we're just applying on this. on
Yes.
our own.
Yes.
You have clearly, no, the authorities, they have, while issuing a notice, NIT, they have said that it will be governed by these rules or the act.
But they
Why
have
not
also
applying
consciously,
ourselves?
they have also consciously
While
called for
deciding
NIT,
this
Lordship.
matter, while deciding this tender matter, why
Yes.
not just because there is a law
Yes,
inapplicable that we are just bringing it on our own?
yes.
It is their own, it's clearly specified and reflected in the NIT.
Yes.
We're deciding on the basis of NIT and the terms of the tender. That's all.
Tender, that is the word, Lordship.
Yes.
The tender also includes my part, Lordship.
Yeah.
Can the court
No, that-
scissor it out, Lordship?
Well, that's why we're hearing. It's not that we're against you or against.
When they are saying, when they have consciously done it, can the court scissor it out, Lordship? That is my question.
Which is negated and contradiction to the act and rules. They cannot consciously do it. Even if they've done it consciously, will not allow it to go. Allow this to stand when it is against the act and the rules.
Lordship, as your Lordship pleases, Lordship.
Only one.
That's all. So we'll not go into that very big ocean of law. I mean, that the sea of
No, the
law-
question, in my humble submission, the question will arise. Because this law, the District-Based Entrepreneurship Act, this law does not give a right. It is only a preference which the authorities may take,
This is
Lordship.
an appropriate
Yes.
case. Here will not, because this case is on very specific, very limited thing that he said the authority has awarded you, even if you have violated or not eligible in terms of the tender. Whether he or eligible or not will, we have heard you.
Only on that.
And a kind of attack against you.
He is also not eligible.
So you have,
He is also, he's
you
just,
have concealed, you have filed a false affidavit, you are not equally eligible. So when you are not eligible,
My lord.
why you are questioning others? First, you have to show that you are eligible. Therefore, you have been wrongly rejected.
No, my lord, I am eligible, my lord.
You are not eligible because as per the rules, you should not have more than 2 works at hand from the department, the state
Well-
government, under the state government.
My lord.
And you are filing a false affidavit saying that you don't have the
Two
works at hand.
my lord.
It's a false affidavit.
My lord.
Now they found that you are having 3 works at hand.
Well-
It's equally a violation of the tender,
My lord.
the rule or the act,
My lord.
which is made to govern the NIT.
My lord.
You are equally fault.
When I'm equally for my lord, but that same law has to be applied to the.
But only
Whoever
when
responded.
I'll see, I'll look into it, whether there's a violation of the terms of the tender.
Only one.
But in any case, you are not entitled. In any case, you are not.
My lord.
You cannot be given.
But there is a.
Number one, you are not L1,
My lord.
though the district board has shown to be L1. In actuality, you are not L1.
My lord.
It is on the face of the record.
My lord.
Number two, you have 3 works at hand. In any case, you are not entitled to the
But
award.
there is a procedure which has been provided, my lord. Let
Now,
the court
even
for
if
the
tomorrow,
president.
if we say that go for fresh tender, still you are not eligible.
Exactly, my lord. That I'm aware
So
of.
will
my
not go for it. Public interest will let him execute the work.
lord. That will
What
no,
you
sir.
say?
That will again prejudice, my lord. When
What prejudice? Even suppose today,
My lord.
if we go direct it for fresh tender,
my lord.
in any case, you cannot be.
No,
Even if we find that
My lord, my lord,
code
that-
number 6
I may
is
not be, my lord.
eligible,
My lord. I may
Yes.
not be, my lord.
that's why I'm saying you have to show your prejudice or your now. Even if you say that go for fresh tender, you are still not eligible.
But for that,
you are having a 3 works at hand.
but there is a procedure, my lord, which says in the first tender.
You are not here to. It's a tender matter. You are not here to. Make good of all the system.
My lord. But then, my lord, since there
You
is
talk about your right. You talk about you stand for your own right. You stand on your own right.
my lord. But then, even if I don't have a right, my lord, When there is a
If
violation,
you
my lord.
don't have a right, matter and stay.
No, she also doesn't have a right. I mean,
Huh?
the paper respondent, my lord. There is a
We'll see.
rule which has been enacted, my lord.
No, what,
but
have you heard what they are saying is there appears to be inconsistency
my lord.
in the tender and the NIT, but it has to be read. It has to be read. And it has to be accept the way the tendering authority has interpreted.
But why always?
According to them, it says that this is should be governed by the act.
Yes.
But then this will only apply so far as the enlistment is concerned.
My lord.
It has to be by the contractor who has registered in Arunachal Pradesh PWD.
No, my lord. No, my lord. It doesn't say
that
so,
is the interpretation.
No, my lord. Whosoever it may be, that contractor has to be registered under the Arunachal Pradesh.
Lordship, I will give the copy of it tomorrow. It is there. In the enlistment rules, it is there.
It has. It can be from any
We'll
works
continue
department.
tomorrow. You improve your case. Let us say,
my lord,
for the time being, assuming that she's not, I mean, respondent number 6 is not eligible.
Yes, my lord.
Are you eligible or are you entitled to be awarded the award? No.
But first of all, my lord, whether I have 3 contracts, 2 contracts, that comes afterwards, my lord. First of all, a person has to be enlisted in the as per the act, my lord. That has to be
It's a
seen.
registered contract. That is it is the interpretation which you are supposed which you will determine.
My lord.
According to them, they have determined, they have provided as such that this is the contractor required to be enlisted is for the contractors of the state PWD, registered under state PWD, not the other contractors. That's why they said the contractors from other state and the organization.
My lord.
Right. That is their interpretation, which according to them, Supreme Court says that it has a deference has to be given. The interpretation.
Okay, ma'am.
It is the interpretation of the author of the tender has to be respected.
But then every
deference has to be given.
But wherever there is
So when they are saying so, my hands are tied.
No, but my lord, whenever there is a discrepancy, my lord, whether it be in the solvency certificate, whether it be but whatsoever, my lord, and whether he's the private respondent then is eligible or not, everything whatever has been done is always in favor of
solvency certificate.
Lordship, I am relying on the submissions made by the Honorable AG. But I have also, in this regard, I am submitting that the solvency certificate or the bid security is to ensure that the person is financially healthy. The end result is to make sure that the work that he has been selected for.
You may be correct.
Yes, selected for. He is capable of completing it. The public interest lies in completion of the work. Now they have, regarding my solvency certificate, they have made queries to the ICICI Bank, and they have satisfied themselves that this would work. So therefore, they have accepted it. It is not the most essential part of the contract. It is something which can be accepted and which they have accepted.
So
they are satisfied that I am financially healthy.
Certificate and bid security is not same thing.
Not the
It's
same,
separate.
Yes.
My lord, only one more clarification, my lord. There is an allegation that.
No, I would like to see that she said she'll provide tomorrow. We'll continue tomorrow. We don't have to hear again. I mean, further.
I'll only simply provide it.
Not simply provide. We'll list it again tomorrow as a part heard. You just make your submission on that.
Only on the
because we'll have to decide.
My lord. But only on one issue, my lord. That my learned friend, he has said that I did not bring the records. So bring on records the other part of the, I mean the later part of the tender process, my lord. My lord, this application was filed on 8/7/2025, my lord. 8th.
The
of
rate
July.
petition.
This at Guwahati in the, the judicial listed on 10th.
Hmm.
Now, 7th, my lord, as per the e-procurement system my lord, of the government, my lord,
Yes.
it is 1:34 p.m., my lord. The e-portal says the status of the case, the status of the particular tender, my lord. It says only financial bid and was opened and it was evaluated. Technical.
When you filed the writ petition.
Yes, my lord.
Now, after they filed
After
they
filing,
filed the affidavit,
my lord.
you don't want to, there's a order, you have sought for a time to file affidavit in reply, you have not filed as on today.
No, I said if necessary, if need be, my lord.
No,
Because
he said
my-
you won't file.
But then I said it is not necessary because my question is not that, my lord. My issue was only whether she is eligible or not because she is
Anyway, I
not
will not go into it,
only
we'll
that
just
part.
go into what is the, the main points which you have raised and countered by them. And so heard Mr. O. Pada, learned counsel for the same, it should be
I think
common order.
if
And Ratan learn addition and again learn the so and so. Hearing remains inconclusive, list tomorrow.
I think
As
there,
part of-
there is no, I think, I don't feel there is furthermore to hear, my lord. And
I think there is no other comment.
No, we'll not hear, we'll hear.
I'll only submit, Lordship, that enlistment rules.
Yes, we'll see and
That will be,
we'll close it.
yes,
We'll see and close it.
I think I'll just
I don't know.
What's the, we'll, 2 minutes tomorrow. We'll see.
obliged.
And if anything you want to make, you may have,
Nothing else, my lord. My only point is I'm harping upon
all of you may again sit back in the evening,
It's in
Reflect-
in fact,
reflect-
Lordship,
reflect yourself.
tomorrow I may go to the Brugger also.
Uh,
Somebody, my family member is sick, so I may go there also. That is, but I'll
so-
make sure
so
to
when
submit
then,
this.
in that case,
Yes.
and when in that case,
No,
not
Lordship,
necessary
this,
tomorrow.
I'll make sure that this is submitted, Lordship.
It's not submission, you'll have to make submission. Why you are relying on this?
Lordship.
Is not it?
No,
Do you have that?
I'm not relying on this. I'm simply saying that under these rules, 2008, only the contractors who are in Arunachal Pradesh, registered on Arunachal Pradesh, are to be
That is
enlisted.
the-
Yes,
That's what I'm saying. That's
Yes.
very relevant. That's what I'm saying.
yes,
If you are saying so, if that is so, it's relevant.
yes.
See, if you are not, if you cannot enlist yourself,
Yes,
what's the question of enlistment under the rules?
yes,
Therefore, it goes in your favor. It
Yes.
goes in your favor.
yes, Lordship.
Therefore, there's no inconsistency in the tender,
Yes,
NIT.
yes,
That can be a case also.
Mhm.
That's why I'm giving you an opportunity.
Lordship.
When you say that
Lordship, I will try.
other, the contractors which are registered, other than people need not be registered,
Mm.
enlisted. That's what I'm saying. Not necessarily tomorrow, day after, it's up to you.
Lordship. Tomorrow, Lordship.
Tomorrow, huh?
Tomorrow, I'll try.
obliged.
Item number 14 and 15.
My lord, I am
Why
appearing
better
in
not-
item number
So
15.
urgent or what, sir? You are insisting on this.
I'll answer that.
What is the
My lord, I am-
urgency?
Yeah, I'll answer that.
May I submit
have
one
me
thing, my
to-
lord, before the, my lord,
Yes,
am I audible to lordship?
yes,
Am I audible to lordship?
yes, yes,
My lord, I am appearing in item number 15.
yes.
The issues are different, my lord, in the item number 14 and item number 15. And today is fixed by the earlier order dated last order, my lord, dated 22/9/2025 for disposal of the appeal,
Hmm.
not my
Ah.
revision, my lord.
So, this may be, my item may be segregated from this item number 14.
Why this has been
I'll answer. The issue here in item
At one
14
point of time, by the earlier order,
I will agree with my learned friend.
on the basis of the
if you agree
submission
with
made by the appellant,
I'm not concerned with.
heard Mr. in the item 14, huh? Heard
15.
Mr. 15.
This is 15.
This is 15. Heard Mr. P.J. Saikia, senior counsel assisted by K. Lolan, learned counsel for the petitioner. And you are respondent there.
One of the respondents.
And who else are there?
No, I'm appearing for respondent number 4.
Respondent, item 15.
I'm
Who is one?
Not in 15, my lord. I'm in 14.
No, why talking of 15?
15, I'll appear.
Hassan Dasang is respondent
Yes,
number
yes,
1.
yes, yes. I'll represent, my lord.
Who is one? Who is one?
Hassan Dasang, perhaps senior counsel is appearing for respondent number 1. Notice was accepted earlier.
Who?
For was minute, I'll just check minute what respondent is
You
there.
record all these names? It is submitted at the bar that what is this?
For civil revision. Civil revision.
Maybe can be segregated from the arbitration FE number 2025. They have let this CRP be segregated from the arbitration so and so. Accordingly, list the matter after
your
whenever CRP
2 weeks, man.
after 3 weeks.
Lordship,
After 3 weeks.
3 weeks, my lord. Can it be on, my lord, 18th, my lord?
3 weeks.
18th of November.
18th. Yes.
Obliged.
In item 14, the urgency is this note and the fourth. There is a contract that is awarded to the petitioner for construction of a national highway in the state of Arunachal Pradesh. I appoint a subcontractor to do a part of the job. The subcontractor is tenor engineer. Now, the entity which is Hachan Tanang before my friend represents files a section 9 petition before the district court alleging that there is an agreement between them and me directly. And gets an ex parte order from there, and the ex parte order is they claim that there are certain dues which are due to them by which is to be paid by them. The order that is passed by the learned court is that I cannot get my bills cleared from ministry. That's the order passed. Now, the first submission which I will make before Lordship is this, that the petitioner before Lordship, which is the respondent in section, is a company incorporated under the laws of Russia, under the Arbitration and Conciliation Act. If one of the parties is a body corporate not incorporated in India, it's an international commercial arbitration. And in an international commercial arbitration, the jurisdiction lies exclusively of a section 9 petition by the High Court, and a petition does not lie before the district court. That will be the first submission. And the urgency is this. I have to complete the work of the National Highways Authority, of the Ministry, by the deadline is 30th of October. Because of this injunction order, my entire bills have been stayed. I cannot get a penny out of Ministry of Road Transport. But your Lordship knows, Lord, these contracts work that I get money and I invest back into the project and I do the work in the project. Because of this order, I have not been able to get a penny, and hence I'm not able to execute the work. That's my problem. And the ministry is after my life to complete the project.
You have a very comfortable chair. Have you? Enjoy the chair. Yes.
So that is the urgency, Lord, which I'm not beseeching your Lordship with. And that is the reason, Lord, my learned friend tried to raise that argument of prejudice before your Lordship, Lord, that look, they have gone to the Supreme Court, Lord. But let me say this, Lord, with all humility at my command, Lord, I went to the Supreme Court because of that deadline of 30th. The Supreme Court, Lord, in its wisdom said that
it's not, at least the court should be affected when there's a provision for appeal. See, personally, I mean, this court, once I decided it's under to the best of my knowledge and ability, who goes where, it's under the provisions, under the law. What matters?
I only said this because my learned friend.
I don't know. Today I passed an order.
Yes.
We'll go where? It's a right of the parties.
Yes.
So whether Supreme Court, appellate, other court, under the law, even if beyond the law also, this court is.
I don't think any of us can say beyond the law.
List further. Once you hear the matter,
yes,
to the best of your knowledge and ability,
absolutely,
you have passed the order. The parties agreed.
I have always
can go
said this.
anywhere.
I have always,
in accordance with
said, Lord, the hardest job is that side, Lord, your lordship.
Yes.
Lord, we argue, it is ultimately your lordship. We will argue whatever our clients is in the interest of our client. It is ultimately your lordship, Lord, which have to decide which is right, which is wrong.
Yes. So what I'm trying to say that the courts should not bother whether your order is been taken to appeal. It's not it. Even the fair criticism is permissible.
Absolutely.
And nowadays the social media, who says what? At least border. But we do the best of our knowledge.
Absolutely.
We pass the order, we decide the matter.
Yes.
That's all.
Yes.
So nothing.
Yes. I am so obliged.
Supreme Court, Honorable Supreme Court, it's your right.
Absolutely.
Under the law.
I'm so obliged for your lordship, Lord, consideration,
Not
Lord, of that, Lord. I just wanted to dispel that argument of
So I
prejudice.
just wanted to know that why this is so urgent.
That's the reason, Lord,
Yes.
I am before your lordship, Lord.
Yes.
And Lord, now, Lord, to begin with,
Yes.
please have a few provisions with me, Lord, of the Commercial Codes Act and the Arbitration and Conciliation Act.
Yes.
If your lordships may have the Commercial Codes Act with me, Section 2C.
Yes.
Bro, it says commercial disputes means a dispute out of, and your lordships may see Roman 6.
Yes.
Construction and infrastructure contracts, including tenders.
Yes.
So, Lord, there can't be a dispute that the present dispute
is a commercial
dispute.
Okay.
Because it pertains to construction and infrastructure contracts. This is a national highway project.
Yes.
So the first hurdle which I had to cross was that whether it's a commercial dispute or not. Now your lordships may kindly have the Arbitration and Conciliation Act.
Yes.
And please have 2(1)(f). That defines international commercial arbitration.
Yes.
International commercial arbitration means an arbitration relating to disputes arising out of legal relationships. Please mark note these words because I will come back to why I am emphasizing in view of their reply. Arising out of legal relationships, whether contractual or not, considered as commercial under the law in force. I've already shown to you, this is commercial in the law, under the law in force in India, and where at least one of the parties is, and please have Roman 2, a body corporate which is incorporated in any country other than in India. So if the commercial matter involves a dispute out of legal relationships between parties, where one of the party to the dispute is a body corporate incorporated outside India, then it's an international commercial arbitration. Comrade, what is, your lordship will pose me a question, what is the consequence of it being an international commercial arbitration? Now that your lordship will find for that, please have section 2(1)(e) with me for a minute. 2(1)(e) defines court, where you can actually go to court. Court means, that's the bottom of the page. Court means, and your lordships may straight away have Roman 2. In case of international commercial arbitration, the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the part arbitration, if the same had been the subject matter of pursuit. Pausing here for a minute. If the High Court has original jurisdiction, then it is that High Court. But the second eventuality, whether if the High Court does not have original jurisdiction, is in the next line. And in other cases, a High Court having jurisdiction to hear appeals from the decrees of the court subordinate to that High Court. So if the High Court does not have original jurisdiction, the court will be that High Court which has jurisdiction to decide appeals from the suits. So like in this case before Lordship,
There is no original jurisdiction.
there is no original jurisdiction.
But
So
jurisdiction to hear the appeals from the
from that, so the court in respect of international commercial arbitration will be a High Court as at as your Lordship are. Yes. So, my Lord, I have been able to show to your Lordship, my Lord, in terms of provisions, that if one of the parties is an body corporate registered outside India, it's an international commercial arbitration. And in an international commercial arbitration, a Section 9 petition would only lie, my Lord, before the High Court. Now, please have, my Lord, the documents where I will show, my Lord, that one of the parties, which is the petitioner before Lordship, is a body corporate which is registered outside India.
So are you disputing?
They are disputing.
Are they disputing?
Yes, that's the dispute, but I'll show that. But they are not strictly disputing it. I'll rephrase the reply. What they are saying is that there is an Indian entity which is the subsidiary of the petitioner before Lordship, which has also been executing works in this project. And hence it is not an international commercial arbitration. What I will be able to show to your Lordship, at the end of the day, when I will take your Lordship the documents, that what your Lordships have to consider as to the parties, as to between which parties is the contract which contains the arbitration clause. If I can show to your Lordship, that the two entities which have the arbitration clause which they rely upon, one of them is based in Russia, then, my Lord, it will be my submission that a Section 9 petition before the district court was without jurisdiction and ought to have been dismissed at the threshold, let alone pass an intent. My Lord, that is something I will beseech your Lordship. Now, please have, my Lord, the document at page 16 of the paper book. Lord, I'm sorry, this is not the document at 16 of the IA. But we had filed an IA before your Lordship, Lord, raising this issue of international commercial arbitration list.
IA.
Lord, I'll come to IA later. Lord, let me show the documents first from your Lordship's main file. In the meanwhile, Lord, please have, Lord, page 53 of the main appeal paper book. Lord. I'm so sorry.
Yes.
Now, please have, Lord, page 53. And Lord, this is a document which forms part of the Section 9 petition which they have filed before the district court. This is a document which I'm placing before Lordship, Lord, is the document which the authority took into consideration, Ministry of Road Transport, while granting the tender in my favor. This is the meeting of the evaluation committee. So, Lordship, let's see the top of the page. Minutes of the meeting of evaluation committee held on 27th May for opening and evaluation of financial bids. Now, please have paragraph 2 your Lordship has. As per the minutes of meeting for technical evaluation held on so-and-so, bids of the following bidders were found to be technically responsive. Now, please see number 2. Messrs. Joint Stock Company Industrial Association was ordained. Lordship, has that right? This is the petitioner before your Lordships and the respondent before the Section 9 court. Now, please have note the second table. My bid price is lowest So I'm declared L1. Please turn over the page at page 54. Just top of the page. Evaluation committee noted that L1 bidder is a firm incorporated in Russian Federation, with registered office in St. Petersburg, Russian Federation.
Yes.
As per clause 2.1.12a of RFP, where on the date of application, not less than 50% of the aggregate issued, subscribed, and paid up equity share capital in the L1 bidder or its member is held by person resident outside India, or where a bidder or its member is controlled by the persons resident outside India, then the eligibility and award of the project to such L1 bidder shall be subject to the approval of the competent authority from national security and the public interest perspective, as per the instructions of the Government of India applicable at such time. The decision of the authority in this behalf shall be final and binding on the bidder. In view of the above, please mark note, the evaluation committee declared the L1 bidder, that is the petitioner, as the selected bidder and recommended for award of the work to the selected bidder for the quoted bid price of so-and-so, subject to the approval of the competent authority from national security and public interest perspective, as per the instructions of the Government of India applicable, at such time and submission of additional performance security of rupees so-and-so as per the provisions of RFP for the work mentioned in the above subject work. So, my lord, even at the time of evaluation of my bid, considering the provisions in the RFP, it was considered that I am of entity which is registered in Russia, and hence I also have to have clearance on the aspect of public interest and the national security.
Yes.
So this was considered. Now please have, my lord, I should have shown to your lordship this earlier. Please have 73. This is an earlier, I'm so sorry.
Yes.
Let's have 73.
Yes.
Look, this is what I had shown to your lordship was the minutes of evaluation committee dated 27th May. This I'm showing to your lordships of 19th May. I should have shown this earlier, but nevertheless, and if your lordships may have paragraph 2, the bids of the above work amounting to estimated cost of so-and-so is invited by the Ministry of on 27th February 20 and opened on 5th May 20. Total 3 numbers of bids were received online from the following bidders. I am number 2 before lordships, my lord. And please have 3.2. The bidder, Messrs. So-and-so evaluation committee observed the following. The bidder is a firm incorporated in the Russian Federation with registered office in St. Petersburg, Russian Federation. The corporate office of the bidder is located in New Delhi. And I'll come to note why that corporate office is in New Delhi. Now, please turn over the page at 74.
Yes.
Top of the page, Roman 3. With reference to clause 2.2.2.52 of the RFP, the technical capacity in respect of eligible project situated on a developed country which is a member of OECD shall be further multiplied by a factor 0.5 and the product thereof shall be the experience score for the eligible project. The above eligible project in Asagat, capital of Turkmenistan, which is a member of OECD. Please have 4. Since the bidder is a foreign firm, provision of clause 2.1.12 of the RFP shall apply. So the evaluation committee again considered that question.
Yes.
Now please have page 65 of this paper book. And these are all documents which I'm showing to your lordship which form part of section 9 petition, which they have filed before the district court.
Yes.
Your lordship, this is a power of attorney which was executed by us to sign the agreement with ministry. Know all men by these present, we so and so, and having its registered office at
you Lordship may see Makarowski Strait, 4A, St. Petersburg, so-and-so, Russian Federation, and corporate office at A11 Gulmohar Park do hereby irrevocably constitute, nominate, and appoint Himanshu Garg, Anil Kumar Goyal, and presently residing as so-and-so, who are presently part of the organization and is authorized for signing the agreement between Joint Stock Company Industrial Association was Green and PWD Itanagar Arunachal Pradesh as our true and lawful attorney, hereinafter referred to as attorney, to do in our name and on our behalf all such acts, deed, and things that are necessary or required in connection or incidental to the signing of this agreement. So this is the power of attorney which the company executes in favor of people for signing the agreement with the MOR. Now please have 67.
Board resolution.
Yes, Mr. So this is the resolution passed by the petitioner, my lord, at the relevant time. Certified true copy of the resolution passed in the meeting of Board of Directors of Joint Stock Company Industrial Association, JSCIA was Green, on 15 September, registered office, please mark, my lord, again at St. Petersburg, Russian Federation. Please have the next document, my lord, at page 68. This is the general power of attorney which is executed, my lord.
Yes.
And your lordship may see just below general power of attorney, it says Russian St. Petersburg, then date is given. JSC represented by the director so-and-so on the basis of article of association hereby authorizes so-and-so, my lord, Praveen number so-and-so, to represent and authorize. Now please have page 83, my lords.
Yes.
This is another power of attorney, my lord, which also shows that the registered office of the company.
Yes, it's okay.
Yes. Now, my lord, just to have two documents with me which are in the IA, and I'll show, my lord, why I am referring to that. What is the relevance of that?
IA.
Yes.
Yes.
My lord, page 16, if your lordship has. Yes. Lord, this is the incorporation certificate, Lord, registration certificate of with the tax authority at Russia of the petitioner before your lordship. This is one. Please have the page 19 is more important.
It's a registration certificate.
Yes, not the first document at page 16 is the registration for tax purposes. 19 is something I want to show to your lordship. That's crucial. Lord, this is a certificate for establishment of place of business. I hereby certify that form number so-and-so filed under section 380 of the Companies Act, notifying establishment of place of business in India with effect from so-and-so by Joint Stock Company Industrial Association was Green, a company originally incorporated in the Russian Federation has been registered. Now, Lord, why I am showing this to your lordship, Lord, is that because when I execute the document which they rely upon shows my address in India. If your lordship may now have section 380 of the Companies Act with me, because this registration is under section 380 of the Company.
Yes.
Your lordship has section 380 of the Company Act.
It's okay.
I'm so sorry.
Companies Act.
Look, section 380 of the Companies. Yes.
Just submit.
Yes. Section 380 of the Companies Act requires that a foreign company within 30 days of starting business in India has to deliver. I'll read has that.
It's okay. You just make it.
Has to inform the registrar a place of business in India. It reads, my lord, every foreign company shall, within 30 days of its establishment of its place of business in India. Every foreign company shall, within 30 days of the establishment of its place of business in India, deliver to the registrar for registration the one is certified copy of charter, etc. B, full address of the registered or principal of address, list of directors, the name and address and names of one or more residents in India authorized to keep. Please have E, the full address of the office of the company in India, which is deemed to be its principal place of business in India. So I am required under the provisions of Section 380 of the Companies Act to notify to the registrar my principal place of business in India. That will not make me a company incorporated in India. I will remain a company incorporated in Russia.
So it's only a place of business.
Place of business in
India.
India.
Registered in India.
Yes.
But your incorporation will remain in that country.
In that country. That's the submission I was making. Now, let's please have that agreement with, just have this chart with me, Milad, because the names are a bit confusing. I've put down on a piece of paper the name. Now, let me see the top of the page. Is the Ministry of Road Transport. The Russian entity's name is Joint Stock Company IA Vozadin. My Indian subsidiary's name is JSCIA Vozadin India Private Limited. Then Lord, my subcontractor is Tenor Engineering, which I'll come to separately. And the petitioner in the section 9 who claims himself to be my subcontractor is Hachantana, which is the last one.
So there's no agreement between you and the Hachang?
Yes, there is an agreement which they rely upon, which your lordships will find at Annexure 6 at page 544.
No, this...
But they rely upon an agreement between Joint Stock Company IA Vozadin and Hachantarang, not between JSCIA Vozadin India Private Limited and Hachantarang. So the agreement which they rely upon is between the Russian entity and Hachantarang. And it is this Russian entity who has been made a respondent in the Section 9 petition. Though they have given the address as India, because my principal place of business is in India, but which is irrelevant, because what is required under Section 2 of the Arbitration Conciliation Act is that the body incorporated should be incorporated outside India. Whether I'm doing business in India or not is irrelevant.
But I'm just asking.
Yes.
Whether is there any contract between you and the respondent?
But they rely upon a document which they say has been executed. I am disputing that document, but and I will show why at the when I come to your lordship on merits before lordship. But for the purpose of this jurisdictional argument, I am saying please believe for a minute that this document was executed.
Yeah.
But this, even if your lordship believe that this document was executed between Joint Stock Company IA Vozadin and Hachantanang, the fact that this is an entity which is unincorporated in Russia makes it international commercial arbitration.
Therefore, jurisdiction lies
before the High Court and not the district court.
That's the only point.
That's the only issue I'm raising as of now.
So whether the correctness of the agreement, yes, it's a matter of arbitration.
Because I will come to when I address your lordship on merits.
No, merits will not go in.
Because
this is what appeal. This is appeal.
Yes, yes.
Okay.
This is an appeal.
Okay. That's the main crux.
That's on the jurisdictional aspect.
Yes.
Let me just show this at one page.
See, when the jurisdictional issue is suppose in your favor.
Yes, then of course
we don't have to go. Everything falls.
Just let me show this document which they rely upon. 544.
Because as on that, on merit, you are agreed by the interim order.
Yes.
Directing not to make payment or whatever.
Yes.
That's all.
Yes.
So merit has yet to be entered into by the arbitration, I mean the appellate court.
Yes.
Is
But
not
you
it?
have to consider that, but still.
No, if the jurisdiction suppose,
If you also find in my favor.
of course, I am not deciding as a, suppose if it is in your favor.
Yes.
If we find that jurisdiction lies with the High Court, matter ends there.
Absolutely.
So why we should go into the merit? And merit is yet to be settled by the, whatever, wrongly or rightly, it has to be entered into by the court. As in today, they have not. Court has not. Court below has not.
Court has. It has gone into the merit while passing an interim order.
No, interim, for passing an interim order, there must
Prima facie view.
yes, maybe prima facie view, but it has not been, the court has not settled on the merit.
My problem is this, Lord.
Yes.
This Hachang, Tanang and Tenor Engineering, which is Lord, my subcontractor,
Yes.
are in collusion. And I'll tell you also what happened in this matter.
Hassan
After
Tanar
what has
and-
happened in this matter.
Who?
Tenor Engineering has the fourth respondent for 5 before Lordship.
Who has?
Subtenant. So my subcontractor.
Yes.
What happened in this matter was they get an injunction from your Lordship by the district court. Tenor, who is in league with them, which will be apparent from the document, files an application saying, please delete me from the array of funds.
Tenor.
Tenor.
No,
There is no relief sought against them. That's the application file. The learned district judge.
Section 9 application is filed by Hachang.
Yes, by Hachang. Tenor is a respondent before the court.
So he files an application.
That delete me, there is no prayer against me. That application is dismissed. Tenor comes to your Lordships in a CRP, the other matter, in item 15, and gets a stay of the proceedings before the Section 9 court. So there is an interim order which will continue against me, but the proceedings shall remain stayed. Very innovative, Milad. Get an order, then get the proceedings stayed.
Who has innovated?
So they are two in collusion. They both have innovated this.
Wonderful.
That's what I thought, Milad, is wonderful, Milad. We all learn every day.
Yes.
Just one document before Lordship, Milad. Please have page 544.
I-44.
Yes. Look, this is the document which they rely upon in the Section 9 petition, saying that this is the agreement between me and them.
Yes. Annexure 6.
Yes, Annexure 6. So it's an agreement which they say is dated 29th August 24. And please see the part. Joint Stock Company IA was it in and Hachantana. And your Lordship may see that one page which I showed you, your Lordship. One page where I had given those names. This is the name of the Russian entity, not of the Indian entity. And Lord, it couldn't have been Indian entity because the work is awarded to the Russian entity. So the address mentioned is A11 Gulmohar Park. I had shown to your Lordship that certificate under 380. My place of business is A11 Gulmohar Park.
It's not your. It's not your permanent office. That is what you are saying.
It's a place of business in India.
Yes.
It's not a registered office. Section 2(1)(e) requires registration of a registered office.
Therefore, you are saying that it's not a permanent office. Your office.
It's not a registered office. Maybe permanent, maybe temporary. That makes no difference. What the section requires is it should be registered in that country, incorporated.
Okay.
This is the office in India. Now, just a few judgments for your Lordship's consideration on this issue. The first judgment, there is an Allahabad High Court.
Just wait. Let us go. Let us see the impugned order.
Yes, Lordship may have the impugned order with me for a minute. The impugned order has not gone into this question at all. Your Lordship may have page 41. Annexure 1.
Is it an expert?
Yes.
Page?
Not page 41.
Page 41 of this.
That's the first annexure before Lordship.
Yes.
Namraj, it begins with present miscellaneous petition is initiated by one Hachang Tana. The Chang under section 9 for an interim relief for restraining the respondent from realizing any further bills in connection with the project. So and so, Durant Council PB Deka has appeared for the petitioner. It goes on. I don't want to read the entire thing to your lordship. These are 45, which is where the operative portion begins. I'll read the rest if I have to address your lordships on merits. Para 14 minutes. You should notice to the respondents. I'm so sorry.
Yes.
So the court passes an order that I am precluded from getting my bills cleared from ministry.
Yes.
Now, Lord, on the jurisdictional issue, there are certain judgments which I want to place before lordship. There is, can I place an Allahabad High Court find one at this court?
So since, I would suggest, since it is an interim order, against the interim order, jurisdiction issue will suffice to dispose of this appeal, is not it?
Set aside the order and send it back. I have no difficulty.
No, suppose if if you are convinced on and if you are satisfied that only your service only then only. So what I'm saying is we don't have to go into the merit at all.
If your lordship agrees with me, of course your lordship will not have to go into the merit.
Yes, yes.
The lordship may have the judgment. And please have paragraph 7 on page 2. I will be beseeching your lordship at page 3.
Present dispute as it would say, no?
Yes. Please have a look at page 3. I don't want to read the entire thing. I'll read the relevant portion.
Yes.
You have paragraph 9.
9.
Yes.
Yes.
7 says that it's a section 9 petition, just to that effect.
Yeah.
Last 3 lines says this was section 9. And 9 says matter pertaining to international commercial arbitration in terms of section 21F. Then I've already shown to Lordship 21F. The respondent company has registered office at Nepal outside the territory of Republic of India and therefore would come within the purview of section 21F2 since one of the parties to the body corporate incorporated in the country other than the lordship may have over the page.
Yes.
Top of the seat of arbitration Lucknow, and therefore in terms of section 2.2, the arbitration proceedings within the parties would fall within the scope of part 1, and any application under section 9 would be heard and decided by the court as per section 2F, which is as under. I've already shown you what is 2F. Please have 12. A perusal of the aforesaid provisions will indicate that in case of international commercial arbitration, the High Court having jurisdiction to hear appeals from decrees of court subordinate to that would have jurisdiction to decide the matter. And as per section 10 of the Commercial Courts Act, in an international commercial arbitration, all applications arising out of such arbitration shall be heard and decided by the commercial division having been constituted by the High Court. Lakshmi then have paragraph 16.
Yes.
Accordingly, in respect of international commercial arbitration, all applications that have been filed in the High Court shall be disposed of by commercial division of the High Court, and therefore the present case of the district court, there is no dispute that the application pertaining to international commercial arbitration shall be cognizable before the High Court, and more particularly before the commercial division which has been constituted by the Chief Justice. So, on the proposition that like this court, Allahabad High Court also does not have original jurisdiction. So it is the Allahabad High Court which is hearing appeals under the Commercial Courts Act.
Yes.
Who will hear the matters under section. Now, in a similar vein, is the division bench of Karnataka High Court.
This is Allahabad High Court.
This is Allahabad.
There is a Supreme Court judgment.
There is no Supreme Court. But I couldn't lay my hands on a Supreme Court judgment. But in fact, to my mind, the issue is such covered that Supreme Court may not have had to rule on it. The issue in this case was in respect of the Section 34 petition. Definition of fault. But paragraph 11, the court defines what is the court considers the definition of court, and then 14. That read 12 was concerned. Thus, from the above, it's clear that in an arbitral proceeding, one of the parties is a national or is a resident in a country other than India. The body corporate which is incorporated in any country other than India, or an association with central management and control is exercised in any country other than India or the government or a foreign company, the same would be an international commercial arbitration, provided further that the dispute arises out of legal relationship, whether contractual or not, considered to be commercial under the law of in force in India. The court which would have jurisdiction as regards an international commercial arbitration award would be in the event of the court exercising ordinary original civil jurisdiction like the presidency courts of Bombay, Calcutta, Madras, and High Court of Delhi, the said courts, and in all other cases, the High Court. And in all other cases,
Para 11. Para 11.
Paragraph 12 and 13. 12, 13, and 14. And 14 is what the court says that because Karnataka High Court also does not have original jurisdiction, hence the latter part of 2E2 applies, and hence it is the High Court of Karnataka who will have jurisdiction over these matters. But in the similar vein is a judgment of the Delhi High Court. A similar judgment. Go on.
You will be enough.
That's the last judgment on the issue.
Para?
You note paragraph 26, 27, 28, and 30. This is in the context of section 29(8), which is the extension of mandate of the arbitration. No, it's on similar lines, but just make a note. Though Delhi has original jurisdiction, but there also the court said it has to go to the High Court because we have original jurisdiction. Then also before the High Court, if we don't have original jurisdiction, then also the court.
Yes.
Now, there are issues which my friend's reply has been. Just take 5 minutes and I'm done on that. Please have their reply for a minute. They have filed it today. I don't know whether it's on your lordship record or not. You can give a copy of the
Petitioners. This one. No, it's here.
That's right. But I believe should be running page 715 onwards are the documents which they rely upon.
715.
Yes. Starts that. Look, the reply, I believe, begins at 702.
There must.
Yes, so
Mr. Hassan Kasam.
Yes.
Yes.
Now, your lordship to see.
This
is a document, to be very honest, on merits. It does not say anything on the issue of jurisdiction. So, I will come back if need be in the joint. Just skip over this document for a minute. Now, please have 716.
Yes.
Now, if your lordship is, my learned friend's reply is, the lordship is at the bottom of the page. It says GSC IE Positive India Private Limited.
signed by GSC India.
Where it is?
No, there's a stamp at the bottom of the page, right side of the
Hmm.
just above the signature.
Yes.
It says GSC was in India Private.
Hmm.
In your logic, you see top of the page, Contractors Reconciliation of Arunachal Pradesh, tenor engineer.
Hmm.
So what you say is that my Indian entity gave a contractor reconciliation of tenor, which is my subcontractor. I'll show the documents and then I'll make my submission.
Hmm.
Now please turn over the page.
Hmm.
There is a bank statement which they have filed.
Hmm.
And your lordship may see there is an entry of 17th December
Hmm.
of GSC IE was the team, 3.5 crores. Your lordship.
Hmm.
It is my learned friend's contention that this 3.5 crores has been paid to them by the Indian entity. So for that purpose, they rely upon this stuff.
Hmm.
Now please have to turn over the page. 718 is the same document which I've already shown your lordship with the agreement which they rely upon between me and them.
Hmm.
And please see 723 to 724 is the payment which they say they have received from tenor.
Hmm.
Then R5, if you lordship have page 75,
Hmm.
they say these are the bills which I have raised the on mod
Hmm.
and received payments.
Hmm.
And then let this the last document is way the extent of the work which has been completed. And there is one document at 728, which is now an affidavit being filed, sworn by an officer of tenor engineering. That's why I was showing the they are in collusion, saying that one document which I placed before Rajat is a forged one, he never signed. That's the document. So we're coming back to the documents. Not one document before Rajat showing that the agreement between us is with the Indian entity. Actually, in terms of section 2, what is required is the agreement between us should have one foreign entity. I have shown to your lordship the name under the agreement is of the company which is incorporated in Russia and not my subsidiary in India. They say in their reply that my Indian subsidiary was carrying out some work under this contract.
Hmm.
Let me assume that for a minute is right. That's the highest that they give. That my Indian entity was executing some work, certifying some payment, certifying some reconciliation. Will it change the agreement between, that's the question I'll ask myself. Will it change the agreement between me and them, even the document which they rely upon? I'm disputing that's a separate question. The fact remains that the agreement is between a Russian entity and an Indian person. And I will take your attention back to the definition. The definition, that's the reason I was showing your attention and emphasizing. The words legal relationship. The legal relationship between the two entities is where one of foreign. But in my respectful submission, Lord, that is the end of the jurisdiction. The section 9 petition could not have been before the court. In the section 9 petition, you just have the memo of parties for a minute. Just have the section 9 petition. An extra 14 for a minute.
Yes,
I'm so sorry.
Yes.
I just have read any 14,
Page.
page 567. Memo part of the section 9.
567. Yes.
Please see the part. Petitioner is Hachankana. But you see, respondent number 1 is Joint Stock Company IA Wasadi. I have given that chart to your attention. This is the company incorporated in Russia. Please see number 2, Tenor Engineering. Please State of Arunachal Pradesh. 4th Chief Engineer, 5th Chief Engineer. Now the name of the Indian entity is JSCIA Wasadi India Private Limited. That Indian entity is not even a respondent in the Section 9 petition. It is only the Russian entity which is the respondent in the Section 9 petition.
This is Joint Stock Company IA.
Joint Stock Company IA Wasadi is the company which is registered in Russia. The Indian entity's name is JSCIA Wasadi India Private Limited. I will not give you logical that one picture was being brought. I have given to logical because that's the reason, because the names are confusing.
Yes.
That's the reason I prepared that chart for flow chart for.
Yeah.
So the Indian company is not even a party to the Section 9. The only party is the Russian entity, and it ought to have been because the work is awarded to the Russian entity. I've shown to lots of those documents.
Therefore, by their own showing, since the
is the Russian entity,
Russian entity, foreign entity,
yes,
registered in a foreign country, I mean, other than India,
yes. And the address mentioned is Gulmohar Park because of Section 380. I've shown to lots of that. Normally, just 2 judgments, and I'm done. These are 2 Supreme Court judgments as to what is the consequence where such jurisdictional issues arise.
do I need to open it again?
No.
No, it's okay. Yes.
That's the paragraph 3. That's the contention of Mr. Rothi as additional solicitor general involvement, which is recorded. So Mukul Rothi done additional solicitor general.
Where?
Paragraph 3. I'm so sorry. At page 569 of the report, the Customary. Mr. Mukul Rothi done additional solicitor general of India and stated and counsel appearing for the appellant complaint. So the High Court and that Ahmedabad did not have the territorial jurisdiction to entertain special civil action. Since no part of the cause of action based on which the application applies arose in the territorial jurisdiction. They contended that those belong were specifically urged the High Court wrongly placed reliance on the judgment of the sporting so rejected the objection and granted the relief, which of course the appellant contended, even on merits is not liable to be granted, like in my case. They contend that since the question of jurisdiction in this case goes to the root of this matter, the issue should be decided first, and it is held that in favor of the appellant, then ipso facto the judgment under appeal is liable to be excised as having been delivered by a court of no jurisdiction. Now, turn over the page. Paragraph 5 is the operative portion. Having considered the arguments advanced, addressed on behalf of the parties and having produced the record, we are of the considered opinion that the question of jurisdiction should be first decided by us before going into the merits of the case. And as a matter of fact, we feel it would have been more appropriate on the facts of this case if the High Court had proceeded under 14.2 by deciding the question of jurisdiction as a preliminary issue first instead of deciding the case on merits. Then your logic may have. Please have page 575, classical G minutes. But it begins with Mr. Desai, then urged to Classical G. Mr. Desai then urged that since the High Court was elaborately get the merits of the case and given a finding in favor of the respondents, in the interest of justice, we should not interfere with the said finding in appropriate claims. We are not inclined to accept this argument of the government counsel because the appellants herein had taken objection to the entertainment of the special civil application by the Gujarat High Court on the ground of lack of territorial jurisdiction in the first instance itself, and the same was rejected according to us.
Yes.
Wholly on unsustainable grounds. As a matter of fact, the appellant on the entertainment of the civil application grant of interim order had challenged the said order on the ground of want of jurisdiction by way of a civil appeal in this court, which have been pending consideration. Therefore, the objection having been taken at the first instance itself, and the court having not proceeded to decide this question of territorial jurisdiction as contemplated under 14(2), he thinks he cannot deny relief to the appellant solely on the ground that the High Court has chosen to proceed to decide the case on merits. This being a judgment of a court having no territorial jurisdiction, the judgment has to be set aside. However, the special civil application cannot be dismissed on the ground because it has been contention of the appellant themselves. The objection filed by the High Court that these applications ought to be transferred in the interest of justice. That's it. Now, one more judgment blood of the Honorable Supreme Court, a recent decision of 2024, and I'm done with this. This is a three-judge bench judgment of the Honorable Supreme Court. Look, this is an interesting decision. I happen to rely upon them in another case. Here, the party had lost in a matter up to the Honorable Supreme Court. When the matter came in execution, the party said that the judgment which had unsuccessfully challenged up to the Supreme Court was without jurisdiction. That objection was rejected by all courts. Supreme Court reversing that decision said that if it is without jurisdiction, even if they challenge it unsuccessfully, even then we will uphold that objection. These are paragraph 40. The legal and practical position of the present case having been up, we hold that a decision rendered by a court and merits of a controversy in favor of the plaintiffs without first adjudicating on its competence to decide such controversy would amount to a decision being rendered on an illegal and erroneous assumption of jurisdiction and thus be assailable as lacking an inherent jurisdiction and is marked the next line and be treated as a nullity in the eyes of law as a logical corollary. The order dated so-and-so is held to be ab initio void and decree drawn up based thereupon is inexecutable. In spite of having been lost, the challenge the court said, since it is void ab initio, we will dismiss it. On similar lines, there are one or two more Supreme Court judges. I'm not reading them, I'm just hand them over. Now, this is my submission on the jury. I'm so glad to have got upon the Indian.
Yes. Please go. My learned friend has submitted extensively on the jurisdictional aspect. So far as section 9, section 21F2 of the Arbitration Act is concerned, my lord, I have absolutely no dispute to that, my lord. My point is totally different. Here, the whole problem is the appellant has not come to this court with clean hands, my lord.
Yes.
Every step of the execution of the project,
Yes.
yes, my lord. As I was submitting, my lord, I have no dispute so far as the legal aspect of section 9, its implication so far as the arbitration or dispute. Lord, if my lord is convinced by my submission, on one point I'll try to finish it off that my friend, being the counsel for the appellant has no locus in this case, my lord. This appeal is not maintainable at all, my lord. I'll try to show as to why, my lord. 5 minutes, your lordship may give me. If goes beyond, your lordship may decide it can be placed tomorrow or not. But I just wanted to impress upon my lord on this aspect only, locus, my lord, locus. For that, my lord, your lordship have to, I'll trouble your lordship to two documents, my lord. One, which is at page 498, my lord. This is the subcontract awarded by the Indian subsidiary company of the appellant here before your lordships to respondent number 5, Messrs. Tenor Engineering, my lord. My lord, the names are quite confusing, and this confusion has been taken advantage of by the appellant, my lord. As my learned friend has given this chart, wherein the names of the parties are given, the Russian company is named Joint Stock Company IA Industrial Association, Vozhrodeny. This is incorporated in Russia. No dispute, no dispute. And this is the foreign entity to whom the government has awarded the project. Now, my learned friend has very conveniently skipped the portion that this Russian company incorporated in Russia has employed its Indian subsidiary company, which is incorporated under the Indian Companies Act and has been given a company identification number. Through this Indian subsidiary company only, the execution of the project is done. Lord, that portion has been skipped. Now, I will come to the confusion created by the name. The name is, for short form, JSCIA Vozhrodeny is the Russian company incorporated in Russia, and JSCIA Vozhrodeny India Private Limited is the Indian subsidiary company of the appellant incorporated in India under the Indian Companies Act. My lord. Now, let me trouble your lordships. Lordship may kindly have Annexure 3 of the appeal, page 498, my lord. This is the subcontract agreement between the appellant and respondent number 5 here in my lord. For the project. 498, my lord. I'm sorry.
490?
98, my lord.
Yes.
Now, kindly see, that is the agreement, first part. Now, kindly have page 499, my lord. This is very important, my lord. May I read, my lord? May I? Joint Stock Company Industrial Association Vozhrodeny. The name used is Joint Stock Company Industrial Association Vozhrodeny, my lord. The same name as the parent Russian company incorporated in Russia, my lord. But the next lines are very important, my lord. A company registered under the provisions of the Companies Act 2013, having its registered office at A11 Gulmohar Park, New Delhi. Why this address is very paramount, my lord, to address the issue that I'm raising before lordship regarding locus, my lord. In this address, my lord, there are 5 companies functioning. 5. Hems Private Limited, Hems Holding Limited, the Russian company having its corporate office there, and the Indian subsidiary company of the appellant is also having the same address. The authorized signatory of the Russian company has the same address. The directors of the Indian subsidiary company of the appellant also has the same address, my lord. The names and address are used to confuse everything, my lord. Now, when this subcontractor agreement is signed, it is signed not between the Russian company who has been awarded the project, but the executable arm of the Russian company's Indian subsidiary company incorporated in India under the Indian laws.
But the work has been awarded to the Russian company.
I understand, but the execution is done by the Indian subsidiary company, my lord. So, for an example, let me just take an example.
No, except for saying that this is.
I'll come. There is one more document.
That particular company is having registered office at Gulmohar.
Yes.
Doesn't say that your Indian company.
No, I'll come to that, my lord.
No.
They play with this name. Now, your lordship, I'll come to that. Lordship may kindly come to page 544, Annexure 6 of the appeal. That is the agreement between the respondent number 4, whom I'm representing, and the Indian subsidiary company of the appellant. Kindly see the use of the name. Page 544, my lord. Your lordship.
Yes.
Joint stock company IA was Rose Deni, the same name, my lord. Private India Limited doesn't come in. CIN is provided. Company identification number is provided. Having permanent office at same address, my lord. It is this name that has created the confusion, and this confusion is being taken advantage of, my lord. There is nothing in this particular document which says that the agreement is executed between the appellant here, which is the Russian company, and also in that earlier Annex 3, which is a subcontractor agreement between the Indian subsidiary company of the appellant and the respondent number 5. The names are one and the same, but the corresponding sentences which says a company incorporated under the Indian Companies Act. My lord,
If it is a subsidiary company, why not the full name has not been?
that is
The
where,
subsidiary
my lord,
company-
they are not here with clean hands, my lord. That's why.
Who?
The appellant.
No, this is an agreement between you and the company.
No, it provides the company identification number. This is the private.
Name is not there.
I understand, but kindly see, my
Name is
lord.
the Russian company.
My lord, kindly see. It's not Russian company, my lord. Page 545, my lord. No, not 545. Kindly have 548, my lord. The concluding part of that agreement, my lord. Kindly see the seal and stamp who has signed on behalf of that company, my lord. Seal and stamp says Private India Limited. Your lordship, have got it? On the witness part as well as on the part where they are signing. It says Joint Stock Company Private India Limited, my lord.
Where it is.
And if the same goes for Annex 3 also, my lord.
Where it says.
I'm just coming to it.
Where is Private India Limited? 440, 540,
My lord, I'm coming to it.
doesn't say so. Joint Stock Company.
Yeah, I'm sorry, I'm confusing with the pages, my lord. It says Joint Stock Company, General Manager, Coordinator, Joint Stock General Manager, my lord. But my lord, when the company identification number is given, it is the Indian subsidiary company because Vosros, Deni Russia company cannot have that CIN number, my lord. It cannot. It cannot be. That is the locus issue, my lord. And my lord, all the bills, everything, all payments are made by the Indian subsidiary company only. But in the agreement, that name has been confusingly used, but that has been clarified by the next line. The company registered.
Registered one is what we call it?
Same
Which
name,
you
but
have
Private
registered
India
here?
Limited.
You know, have that chart. The registered entity is JSCIA Bothering India Private Limited.
Yes.
It's a subsidiary company.
Yes.
Okay.
It's a registered Indian company, my lord.
And that name does not figure anywhere.
In this.
No, there's nothing. No, reference cannot show any.
Where is your, how you have been registered in India?
Under section 380 of the Companies Act, I showed you, Lordship, sir.
Huh?
That is document number.
No, just tell me that to register in India as a foreign country, company, under section 380, you have registered in the same
No, my lord.
same name.
No, my lord.
It is in that name only, Russian entity's name only.
That's what I'm saying.
Yes, it is not an Indian entity's name. That certificate, your Lordship, have page 19, is in the name of the
Yes,
Russian entity only. It's not in the Indian entity's name.
My lord.
If that is the confusion,
My lord,
So according
I have no-
just wait. According to you, this is the contract given to the Russian entity, and although this you have the subsidiary company, there is no agreement between the subsidiary company and this.
It is not their claim also.
Huh.
It is not even their claim that there is any agreement on record between JSCIA Bothering India Private Limited and Achankara.
Huh.
That is not their case.
Huh.
It is exactly my case, my lord. Exactly my case.
Is in the name of Joint Stock Company IA Bothering, which is a Russian entity, and Achankara. You read the agreement. You can't shy away from the agreement which you have presented.
Exactly my case, my lord, that there is an agreement between. My exact case is opposite. I don't have a contract with the Russian company. I have a contract with the Indian subsidiary company. My lord.
That India contract.
Please, my lord.
Who is that subsidiary Indian company?
My lord, that is where the name confusion has been taken advantage of.
Who has taken the advantage?
The appellant. Because on the one hand, they say,
See, when you have no, when there is no agreement between the Indian subsidiary company,
no, I do have, my lord, page
your grievance is against the Indian subsidiary?
Yes.
Indian company?
Yes. That's why I say the appellant has no locus to file this because Section 9 petition that I have filed.
There is no agreement between the Indian subsidiary
No,
company.
there is.
Where?
There is.
Where it is? 544 is with the appellant.
No, my lord. Please don't be, my lord. Don't
go
be,
by the name.
No, my lord. Kindly see that name is qualified by that company identification number is only given when a company is registered in India.
Subsidiary, this thing is given. Why not mention full name?
That is why, my lord. My lord, there is a whole background as to how this agreement came to be executed, my lord. This is 2024 agreement, my lord. I have been doing the work since 2021, my lord. It's their own document which says so, my lord. It's their own document which I have filed in my reply. That's why I'm saying all throughout that my Section 9 petition is against the Indian subsidiary company. But just because the name have been confusingly used in the agreement, Lord, let me just give a brief background of just on this point only.
Who is party before whom you have added as party?
Indian subsidiary company, my lord.
Before the Section 9.
See the Section 9 petition?
Yes.
Let's see what the name they have given.
Yes.
There, let's see Section 9 petition.
It has to be seen, not just the course title, even the contents has to be seen. Kindly have the Section 9.
Are you saying that he is not a party?
No, I have not been a party. My lord, kindly recollect my first submission before this honorable court regarding
how you derive from a.
If my first submission is that the Russian entity is not a party, I may clarify that there is no stay order against the Russian entity. I have no problem. I have no problem.
Yes.
No problem.
Please clarify.
Yes. Then he will withdraw this appeal.
Cited that there is no injunction against the Russian entity. No difficulty.
We'll record that. Therefore, he
no problem,
close the appeal.
My lord. No problem at all. But kindly see, your lordship wanted to see that particular Section 9 petition. Let me just see, my lord. Even
see, if you are saying that they are not party in the Section 9 petition, they are not.
I can only seek grievance against a party with whom I had an agreement.
Yes.
That
so are you
agreement
saying that the appellant is not a party?
I'm saying appellant, I have not made him a party in the.
Appellant is not connected.
Yes, I am not saying I am, my lord, I will make it very clear. Section 9 petition is against the Indian subsidiary company of the appellant.
Your lordship may clarify that.
Yes.
So there is no grievance or the petition or the Section 9 petition against the appellant. You say so.
That is exactly my case, my lord. On locus part, that's why I said that it is not maintainable, my lord. It is not maintainable. And this will cover the jurisdiction part also, my lord.
See, look at us in a very simple way.
Please, my lord.
Let us look at this. See, the contract was awarded to the, work was awarded to the appellant.
Please, my lord. Please, my lord.
And you have entered into a contract to work as a subcontractor. For that work, who is liable, in fact?
Lord, let me just give a brief background, my lord. When this contract was awarded, there was a discussion in the ministry level as to whether this work can be executed by the Russian company. There was this.
So wrongly or rightly awarded?
Yes.
It has not been awarded or what?
Now, later on part, the Russian company wrote to the ministry, the concerned government authority, saying that there's some problem. So even all financial payment bills, everything should be given to the Indian subsidiary company. So that is why, that is the reason, exact reason as to why this interim order is against the Indian subsidiary company. Because Indian subsidiary company is authorized to receive payment, everything. And they receive.
Is authorized by him only?
Yes.
Authorized by
executing arm. Yeah. I will only go against the party with whom.
It's a kind of, he's a principal.
I understand, but it
It's
has
a
been,
principle.
my lord, let me just take
It's
an
not it.
example. Let me just take an example.
No, no,
Any foreign company.
let us simplify the facts first.
Yes, my lord.
Simple way is the principle.
Yes, my lord.
It's not that work has been awarded to the principal of the subsidiary company.
Yes, my lord.
It's not it.
Yes, my lord.
So he is liable. Whatever is there, his liability is there. And you have been authorized, the company, subsidiary company has been authorized or whatever to do the work or to receive whatever.
Please, my lord.
But the facts remain that work has been awarded to the appellant. Isn't it?
Correct, these are section and petition at
Ah,
568. Just have that one page.
I have seen it.
568 first line says, but pursuant to a tender process, respondent number 1 was awarded the work. So the award, he has made that entity a party. To whom it was awarded? How can he
And
today?
he has to be a party.
No, my lord. I am so sorry, my lord. It cannot be read in piecemeal, my lord. If section 9 petition is to be read, it has to be read. There are 1, 2, 3. That will make it very clear. They will make it by reference to respondent number, because in the subcontractor agreement, which they had entered into with the respondent number 5, the narration is the same. A company registered under the Indian Companies Act as an Indian subsidiary company of the appellant, then the narration comes that the first party has been awarded the contract.
Who has entered into the contract?
My lord, there are two agreements.
Subcontract.
Subcontract first.
You are trying to avoid the name of the company. Only they relying on the number of the registration.
My lord, if it is a Russian company,
it is you who has signed the agreement.
Yes, my lord.
How you can say that they have taken advantage of that?
My lord, that is where this whole confusion comes, my lord. If it is a Russian company, my lord, agreement is between.
It is between you and the company. Why it's your agreement. It's not agreement.
My lord, will it make any difference? Suppose my name is Anthem Henry. I have a bar registration number. So I just write my name as Anthem and write my bar registration number.
That is completely different.
Exactly, that has happened, my lord. If it is a Russian company, my lord, for one second, my lord, let me just, it's a humble request, my lord. It's a humble request, my lord. If it is a Russian company with whom I'm entering into an agreement, will the Russian company knowingly and deliberately write the company identification number of its Indian subsidiary company? That is my submission, my lord.
Is it so?
Yes, it has written. The CIN number has been written.
CIN number is given. Why not full agreement, full name?
My lord, that is where
Who had entered agreement with you? Who has entered agreement with you?
Both the parties entered into the agreement.
With whom?
With the Indian subsidiary company.
Then why the Indian subsidiary company has not been clearly given?
My lord,
you have not entered into an agreement with them.
My lord, will that
have you entered an
difference?
agreement with the appellant?
Not with the appellant, my lord.
Then,
my lord,
when you have entered into an agreement with the Indian subsidiary, why not full name?
I understand, my lord, that part is lacking, but that part has been very satisfactorily answered by.
So are there any this interim order, the injunction, I mean section of the orders, is it affecting him or not?
My lord, as far as that point is concerned, as far as that
is
point
it
is concerned,
affecting the appellant here?
My lord, I'll answer it in a way, this way, my lord.
See, one thing you are saying that he is not a party.
Please, my lord.
He has nothing to do it.
Please,
He's not been made a party.
Please, my lord.
So obviously there will not be any effect. I mean, the order will not affect to him.
That is why.
But ultimately, what is it? No payment, nothing.
No.
So it is the work has been awarded
now
to him.
the appellant is not receiving any payment for the project. Appellant is not receiving any payment. All payments are received by the Indian subsidiary company.
So who is the party? Whom you have made party? Under section 9 petition.
It's the Indian subsidiary company, my lord.
He's made a party, the person.
So you have just kicked him out.
My lord, I can only file a case for grievance with whom I had entered into an agreement, my lord.
The agreement, except for the CI number,
please, my lord.
Name is the appellant.
My lord, CIN number, I believe in my submission, humbly, that it is more than sufficient, my lord. My lord, CIN number will never come in if it is a Russian company, my lord.
What's the wrong in giving the full
I understand, my
full
lord.
name
That,
of the
that lacuna is there, my lord. That
if you have
lacuna is
entered
there.
into an agreement
My lord,
with the Indian subsidiary,
please, my lord.
what was the, I mean, harm in giving you, how you have not get the full name of the Indian subsidiary company?
My lord.
And you are saying that he's not an agri party and he's not related, he's not a necessary party, whatever.
My lord, my submission is this.
No,
If it is Russian company,
yes,
my lord, CIN number will never come in, my lord. Never.
I understand.
I understand, my lord. I bow down that
That
I
part,
have no,
that will
I
not
have no
co- that-
reply.
That will not come.
I have no
Why?
response.
Why? His name is there.
My lord, the names are same except that private limited company.
Why don't you have put the private limited company?
My lord, that lacuna, I cannot fill it up right now, my lord. I can only try to answer that satisfactorily to my lordship's satisfaction that CIN number will sufficiently
Understand. Why? You are saying that he doesn't have the locus. Appellant
Yes.
doesn't have the
Yes.
locus. He's not necessary party.
Yes.
He's not affected by
My
the
lord,
order.
let me just take an example just to answer that, my lord. There are many foreign companies executing work in India. They execute 2-3 ways through a
Let us
joint
do one
venture.
thing. We'll continue tomorrow.
Please, my lord. Please.
And I think it's better if you can, if you are not.
I have already
if- no, if
suggested
you-
for settlement,
no,
my lord.
if you are not inconvenient, we'll continue tomorrow. Can you give the written argument?
Yes, prepared. We are prepared.
Yes. Please.
Better.
We are prepared. Submission.
Short, not that big one.
Yes, it's not 3-4 pages.
Not give this. This
Not
much
more than 3-4
voluminous
pages.
this. Huh?
Not more than 3-4 pages.
No, I have not submitted on jurisdiction point. That will be.
No,
connected
I
to
have
this
not
point.
heard you.
Yes, my lord.
We just were on that. Why you are saying that he doesn't have the locus?
Yes, my lord.
He's not a
Lord,
necessary party. You have no contract with him, with the appellant.
Please, my
So
lord.
that I try to understand.
My lord,
We have not started also.
I may require.
We have not heard you.
No, I may require. Situation has arisen that I may have to place on record the incorporation document of the Indian subsidiary company to show same exact location, same address, along with 5 other entities. The directors, authorized signatories also have the same thing, and they are residing there also.
If it is relevant, we'll see. If it is not relevant, we'll not.
No, it is relevant, my lord. Confusion has been created for that.
No confusion.
Lordship, one matter is there, Lordship.
Yes.
Lordship, may I, Lordship.
Item number 41, unlisted.
Lordship, yes.
So learned counsel for the petitioner who submits that he has an instruction to withdraw this writ petition. Huh? Writ petition.
Lordship,
According
liberty
to
may,
What liberty?
liberty may be considered. to
Which
file
is liberty to file a fresh. Accordingly, the persistence dismiss on withdrawal as with the liberty as paid for.
Obliged, Lordship.
We'll see. We'll see.
We'll be here.